hear no one knew that you're supposed to send those to the University of Florida.
Really?
Yeah,
What for?
they want to
No, what do they do with them?
make hamster bedding, I don't know.
Okay.
But, so no one knew that.
No.
That's gonna be a chore.
Yeah, no kidding. Sounds like we need an intern.
I think so.
How you doing?
Good. Mics are on.
Just let the rest of the mic.
Good looking out, Coach.
Yeah.
What is it?
Cussing.
Legs are
The what?
legs are does Christian dogs that came after that part, right? Oh, no. He does that.
You do that.
Yeah.
Big part of
He
that
does
challenge
that.
is gonna be the wisest stuff.
Then he speaks.
So I do staff update and then write
Yeah,
it.
but your staff update is just, no, actually,
I thought he doesn't he say something
Yes,
between there?
he does.
That's what I thought.
yes.
Make sure. Thank you.
Because it was April the 27th, something like that, switch it.
One of the other moms whose kid made it.
Oh,
She says, I don't know what to say. My heart's sad for Eli. But that with the
that's
text,
perfect.
That's why I said, I'm like, sounded. Because that's awkward.
It is. It is. But if they pick everybody, it's not special.
He literally plays second base. Has no idea what's going on and eats his glove. Literally. Like, eat that glove. Out of your mouth.
So gross.
You can't play baseball with gloves in your mouth. So gross.
Yes, it is.
More visitors.
Hmm?
I said more visitors.
Yes, I was.
Oh wait, what was the word you just? Ballard. Thank you. Amy's laugh.
Mason.
Thank you.
So I can't, this is a new one, and I can't figure out how to get it. It won't, you know, like when you plug in a USB to the computer, it opens up a new drive?
Go to that file folder. Click on that file folder, and then
Which file?
scroll like if you were to go into the F drive.
Mm-hmm.
That file folder
Mhm.
down at the bottom of your screen.
Mhm.
Click on that and scroll. It'll pop up in there.
Really?
For some reason, it doesn't always pull up like a new, like a message
You will,
telling you it's
you
there.
will show me.
I will show you.
Because the thumb drive did, but when I put this in, it didn't.
And some of them don't for some reason, and I don't know why.
Well, I sent an email to the
Because when I
company.
used to plug my phone in that way, my phone wouldn't always do it. But if I went into like the different, like the scan folder, the F drive, like it'll pop up in there
Oh.
as another drive.
Your chainsaw.
Morning.
Good morning.
Good morning. Certainly seems to be an audience today. Let's see. Okay. All right. Are y'all ready? All right. Good morning. My name is Christian Wan. I'm the Special Master. I hereby call this May Code Compliance hearing to order. At these hearings, we follow an agenda. So the first item on the agenda is the call to order. We just did that. The second item on the agenda is the pledge to the flag. So I'd like to ask you to join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay. So ladies and gentlemen, I want to, actually first let me take up the next item on the agenda. It's approving the minutes from the Wednesday, April 17th, 2024 hearing. I have reviewed the minutes. Are there any proposed modifications or changes to the minutes as currently formulated? All right, I don't hear any, so I'm going to go ahead and approve the minutes.
Staff update, the abated and continued cases are posted out front.
Okay, thank you. All right, so ladies and gentlemen, again, my name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over this hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I would appreciate it if you pay close attention. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call the case and I will allow the county to present its case. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and to make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. I will also ask that whether or not you are contesting the violation. If you do not contest the violation, I will assume a factual basis for the violation exists and proceed to ask how much time you need to fix the violation or to work with the county. This will help save time for yourself and others, but you are by no means required to do so or to indicate that you're not arguing. If you do oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and be made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys, including me. In most instances, if you are found guilty of a violation, the law requires that I give you a time to comply before the fine begins. You must fix the violation by that date, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county has the right to foreclose on that lien or seek money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs as well as the cost of the lien imposed. And although it has only happened very few times in my years as a special master, I may continue your case if I find the need for further evidence or argument. Are there any appeals of orders to demolish? Or okay. Ladies and gentlemen, you do have the right to appeal any order that I make today as provided by law. Thank you for your attention.
First case on today's agenda, Cynthia L. Wilson, case number 2023-01324, Code Officer Brandon Norman, page 30 of your agenda.
you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning.
Good morning.
So this is for a fine appeal. This is for 105 East Inverness Boulevard, Inverness, Florida, 34452. This is for case number 2023-01324. Property owner listed as of today as Vance C. Hill at 101 East Inverness Boulevard, Inverness, Florida, 34452.
I'm sorry, what was the address?
For the new owner,
No.
there's a new owner listed as of today, but this is for a fine appeal from a previous code violation.
Okay, I just thought you gave an address of 101 East Inverness.
For the new owner, I did.
The address of the violation?
Yeah, the address of the violation I mentioned is 105 East Inverness Boulevard.
Okay.
So yeah, this is just a fine appeal for the code violation for case 2023-01324. As of yesterday, the property remains in violation.
So this is your fine appeal? Are you Ms. Wilson?
I am,
Okay.
yes.
So the purpose of a fine appeal, I guess, is it's really your motion. It really has usually little to do with the county unless the county's doing the appealing. What is your basis for an appeal of the fine, and what is the fine?
Well, the property was sold February 12th. And the new owners signed in the closing statement a directive that they would be responsible for getting the property cleaned up and getting the code violation closed. And they have since the property has been sold, they've cut down some trees and put limbs and stumps and all that in the swale. So, my mother, the property backed up to her. It was really her property, even though she had it in my name. She can barely walk to the mailbox, so the trash obviously wasn't from her. She had her lawn man go and pick up the trash that was in the swale. So as far as we knew, everything was picked up, everything was fine, but the violation wasn't closed. And so the new owners were supposed to take over, get that cleaned up, whatever they had to do with the county to get it closed out. And since then, they went back and did more inspections and found, obviously they cut down trees, put it in the swale. And so there's further violation. But as of February 12th, the property is no longer owned by myself. So I don't know how this pertains that we were fined in April. So we did the best we could. We picked up the trash that they had said was there.
Well, it says here, and Mr. Norman, tell me if I'm wrong, but based on the information I have, it says that 30 days were granted from the date of the order, which was February 23rd. So the hearing, I presume, was after the change of ownership. Is that right?
So the way it works for us is the morning of the hearing, we check to make sure and verify that the property still belongs to who the hearing is being held for. As of the morning of the hearing, it was still listed in Ms. Wilson's name. I do have a log note dated here for March 5th, 2024. I returned a phone call to Cynthia Wilson in regards to selling of the property on 12 February 2024. I had a note on my desk that she asked for a call back. When I spoke to her, I explained to her that even on 3/5/2024, the PA still reflected Cynthia L. Wilson as the property owner. I believe she was.
I'm less concerned with that, I guess. What I'm curious, you would have opened the case, even though the hearing was in mid-February, you would have started the case
100%.
months before that.
So the initial notice of violation, that was issued on 12/27/2023. The property was posted, or the NOH was, excuse me, issued on, it was sent via certified mail on 1/26/2024, advising of the 2/21 hearing
So I
date.
guess what I'm hearing here, Ms. Wilson, not to belabor this, is that during your ownership of the property, the county opened up a code enforcement case on the property. And it proceeded for at least a month and a half while you were still the owner. And the hearing took place a couple days after the ownership changed. Now, in the Citrus County Code, my understanding is just conveying a property doesn't avoid liability, because if that's all it took, a lot of people could avoid major fines just by trying to give the property to someone else. Does that make sense?
Yeah, well, we didn't give the property away. The first notice we received was January 16th.
Right.
And we did clean up the trash that was in the swale. And I did call Brandon Norman, and asked him to call me back. He did not call me back. In fact, I do have all my phone records.
Okay.
I never received a phone call back. So the next notice that I received was the order imposing the fine. I never did receive the certified mail to come here to court, that there was a fine. And as
You
far
didn't
as,
receive a notice of hearing.
I did not.
What they're saying is, I think you're saying it was posted at the property. Was
So
that,
the notice of hearing first has to get sent via certified mail, and if there's no return service on that, then we post it at the property.
was it posted on the property?
It was in
this-
fact posted on the property on February 7th, 2024.
I would like to see the pictures for that, because we drove by the property
No,
after.
we're not relitigating the evidence. That was at the hearing in February. So when you have a fine appeal, the reason for a fine appeal, there's a couple of them, but one of them isn't to relitigate the evidence from the February hearing. Now, the county can seek liability against the new owner, can seek liability against other parties, but is it your testimony that you complied and brought the property into compliance by the February hearing?
We did, as far as we were concerned. We tried to get a hold of Brandon and ask him, is this what you were looking for? We did not receive a phone call back, as
Now,
I can
that may be a
show in my
grounds.
phone records.
That may be a ground for a fine appeal. In other words, if the property was brought into compliance, but I don't usually issue orders finding that a property is not in compliance unless you've shown me photos of the day before the hearing. Did you do that in this case?
Oh, I always do a pre-hearing inspection the day before the hearing.
Do you have those
I do have
present?
those available, yes.
Could you show them to Ms. Wilson?
sure can.
And then I'd like to take a look at them.
Of course.
So what I'm asking him to show you is the photos that we received in the February hearing that show the property was still in violation at the time of the February hearing.
Right. We wouldn't have known what he was looking for, because as far as we knew, yes, this is the new owners. This is all the new owners. They cut the tree down after they purchased the property, so that is theirs.
Okay?
That's all theirs,
Okay.
after the property was purchased.
Okay. Yeah. All right. Y'all have already taken a look at this?
We saw them the first time they came
Okay,
into
all right.
evidence.
As you can see by the first violation in December, that's not what the violation was
Okay, so
those
that's
trees.
interesting. So now I understand what she's saying. So you're saying that even though there might have been something at the beginning, y'all fixed what the
Right.
case was started over.
Yes.
By the time of the February hearing, the new owners had come in and performed what I see in these photos.
Correct.
Does that make sense, Mr. Norman?
That does make sense to me. I do believe that there's still residual tree debris that was
So,
initially
yeah,
inspected.
what started the case?
So I had a complaint for junk and debris. I went out and inspected it. There was a down tree on the rear of the property. There was also trash and debris that was mixed in.
Do you have photos?
I
of
do. I
that?
have all those photos from the previous inspections as well.
Again, can you show them to Ms. Wilson?
can.
And then,
And in fact, it was the people that purchased the property that started the violation as far as complaining about it. Yes, this trash was picked up, this was picked up, that was all picked up, all the junk was picked up.
so let me tell you what I'm gonna do, it's because I want you to look at these photos with an eye towards what I'm gonna do. I'm gonna compare the photos, so if there's things that existed in those photos that still exist in these, I'm gonna find that it wasn't fixed, and that
Right.
the award is proper. On the other hand, if it shows that those things were fixed, and this is all new, I may sustain the appeal, so.
Right.
Yeah,
And as far as, we did the best we could, we did not know,
okay.
as far as we knew, to pick up the trash. We did not know, to the extent that the violation was, because we never received a phone call.
All right, thank you. right, so Ms. Wilson, I just want to talk to you about this. I do see two things from the December photos that are still present in the February photos. So actually, let me ask you first, Mr. Norman. So is one of the, I see two things, all right, that remain. One is the fallen tree / large stump, I don't know what to call it, near a fence. The other is the pile of vegetative matter, I guess I'd call it. This is on the second February 20th photo and also appears in the, let's see, photo dated. I mean, there was stuff cleaned up. There was
No, I
a-
agree.
a
There were some items that were removed.
There's a photo from December 26th that appears to be the same pile from February 20th.
I would agree.
But I think what they're saying is they couldn't, I think, Ms. Wilson, what you're saying is you wouldn't have known to pick that up because you didn't get guidance from the county, is what your argument
Correct.
is.
Yes, we did not know what they were saying we needed to pick up. So as far as we knew, it was just the trash and whatever was on there, which we did have picked up.
You know, Ms. Wilson, regardless, the code section does prohibit accumulations of vegetative waste. The notice of violation does have the code section. It's not the county's responsibility to tell you exactly, you know, I mean, what's the county's position? Did you get phone calls? Do you know?
The only log note that I have for contact with Ms. Wilson was a note that was left on my desk, and I did make the effort to call her back, and I even put in my log note that I left a voicemail requesting a call back.
There is nothing in my phone records. There was no ever any voicemail, so I don't know what number was called, but it was not my phone, as I can show on my,
Does the county
List of-
believe that there is a legal basis to sustain the order or the fine?
Yes.
What's the basis?
Well, based on the photos that were shown at the original hearing and today, it shows that the original violation still existed the date of the hearing. And pursuant to statute and what you've already stated, selling the property doesn't wash her hands of the violation and doesn't suddenly make it so she's not held responsible for what happened
How
on her
can
property.
she fix it at this point if she's not the owner?
Honestly, she hopes she has a good relationship with the new owner. I mean, it's
I mean, I actually agree on the first part. I think that it's clear that there's still things from December that weren't cleaned up. But if she's no longer the owner, the fine will continue to accrue. And I just don't know on what basis the fine should continue to accrue if she has no ability to bring it into compliance.
if it's not abated, we can't. I don't believe by statute we can grant the fine appeal. And at this point, it hasn't been abated as of inspection yesterday.
Is there a case open on the property right now
This-
with the current owners?
No, this is the active case that we have currently.
But, I mean, they also did sign in the closing documents that they were going to take all responsibility for the open
So
violation.
what that means is you have a lawsuit against them. It's not the county's job to enforce that, it's your job. So to the extent that a fine continues, if they accept responsibility for it, and I'm not your lawyer, I really encourage you to consult a lawyer, but my understanding is you basically sue them for what's called indemnification, contractual indemnification, saying that you owe me the money. You know, to the extent that I have a fine, it's yours to pay under this contract, but it's really not the county's business.
Okay, my mother does not have a lot of money to,
It's not your
Handle-
mom. I mean, you're Cynthia L. Wilson, right?
yes, but it was her property, and in fact, she's the one that ended up receiving the funds because the contract ended up going to her. At closing, I gave her the property and she received the funds because it was, in all actuality, it was her property.
Well, one of you has the right to enforce the indemnity. I'm going to deny the appeal.
So what exactly does that mean? I mean,
It means means that the order stands, and if you want indemnification, you wisely obtained a remedy in your contract, so that would be your remedy. Thank you.
Thank you.
You have the right to appeal my order.
And how do you go about doing that?
Consult a lawyer.
Okay. This is crazy.
Next case on the agenda, Arcadio Morales Jr., case number 2023-01371, Code Officer Cody McGuire, page 21. Okay,
This was the continued case.
Yes.
Okay.
Page 21 of your agenda, expert on the cases, Land Development Director Joanna Katu.
Mr. Morales,
Hello.
do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Good morning. Thank you
Morning.
for coming back. I know it was an inconvenience. Mr. Morales, have you had the chance to review the county's brief on this?
I did. I have a quick 60-second read
Oh.
in response, if you'd allow.
Sure.
Cool.
Can you back up from the mic just a skosh?
Say again?
Can you back up from the mic just a skosh? You're echoing
Yeah.
back through.
Okay, sorry. I thought when I heard you guys can hear me good?
I
I thought when
just
I don't
fine.
hear myself, you guys couldn't hear me.
No, I'm
It makes
fine.
sense now.
Go ahead.
I'm Arcadio. Thank you guys for giving me the opportunity to speak today. I stand here today to defend Happy Campers Rescue Ranch. It's a business that operates not only within the legal bounds of Florida Statute 559.955, but also with the character of our community. I've reviewed the brief submitted by the Citrus County Code Enforcement, and I understand their concerns. However, there is a fundamental misunderstanding about the nature of our operation and how that integrates into the residential fabric of our neighborhood. Firstly, the notion that parking related to our business exceeds what would be expected at a similar residence is incorrect. Our property, like many others in the area, are surrounded by farms and accommodate similar, if not fewer, vehicles than our neighbors. At any given time, other properties have visible RVs, trailers, tractors, and multiple vehicles. Our operation allows for only 5 guest sites, which is conservative compared to the visible equipment and vehicles on the surrounding properties. And unlike others, our setup is not visible from the road. The only thing passersby see is the natural screen of trees, maintaining the aesthetics of our area. Our business model, which allows guests to experience the beauty of nature, involves minimal infrastructure. Our guests occasionally use their parking spots for a tent or stay in their vehicles, which is a temporary and unobstructed use of the space. This is akin to having friends or family visit, a common practice in any residential area, which our local code does not limit. Furthermore, the complaint from code enforcement was not triggered by community reports of noise or excessive traffic, nor does it involve the use of heavy equipment. We maintain up to 3 U-Haul trailers at a time, and sometimes a box truck, a quantity that is insignificant in altering the residential character of the neighborhood. In fact, as stipulated by Florida Statute 559.955(3)(b), the use of the property is consistent with the surrounding residential uses because, from the road, our ranch remains invisible, except for the natural flora, unlike neighboring properties where you can clearly see various personal items and heavy equipment used for farming. I assure you, our business does not change the appearance or increase the footprints or parking compared to the neighboring properties. It is crucial to understand the essence of Happy Campers Rescue Ranch. It is to blend in and preserve the residential character of our community while offering a unique, educational, and interactive experience with nature and our farm animal residents. It is not for profit. I urge the Special Master and all concerned parties to consider these points and recognize that Happy Campers Rescue Ranch operates in full compliance with our local statute and embodies the spirits of our community values. Thank you, guys.
Thank you. Does the county have a response to that? Or does-
At this point, we would rest on the brief that we have filed and the evidence that's already in.
Yeah, I'm not going to take other evidence. I think that, first of all, I was very surprised when you brought up the statute because I think it was a very interesting and novel argument, so I had to be briefed on it. I think you both, or at least the county even conceded that it was a matter of first impression. In other words, I haven't encountered that in this hearing before. I was very intrigued by the argument. I am persuaded by the county's brief, and the reason is that I think even though you've made a compelling reply, Mr. Morales, the issue is in keeping the residential character, it's the primary. This statute protects uses of a residential property where it's primarily residential and wholly residential. In other words, someone who lives and sleeps in the house but then works at a computer in the office room, and there's not outward commercial character uses of the property. That's one thing. And then they made an argument about the transient lodging issue, which wasn't argued in your reply, and which I also find persuasive. So you have two issues. I think you've made a pretty good attempt at rebutting the first one. There hasn't been an attempt to rebut the second. And so I am going to find that there is a violation, or not that there is a violation, but that there was a violation. And that at least for our purposes, the activities that are in evidence were violations. So I will issue an order to that effect, and you will be able to appeal that, and you've laid the record for your statutory argument.
Okay, so this you're saying that this statute does not protect the business that I'm doing from my property?
It does not protect the businesses that the evidence showed you were running on the property, yes.
Okay, per what fact?
The facts in the record.
Okay,
All
one,
the photos.
you said one being that, what was the first
There's
one?
two arguments.
Yes.
They're both contained in the brief. They're both valid. I incorporate them into my order. When you get the written order, you'll see exactly
No,
what
I
the
need
basis
you to,
is.
if you can, just repeat what you said prior to this. You stated two things.
No, sir,
that
I
you
will
were
put it in the written order, so you'll be
Okay.
sure of exactly what it says. And that will be, if you choose, you'll be able to appeal it.
I'm appealing it right now.
You can't appeal it to me. You have to appeal it. It'll go up. You can appeal it to the circuit court.
Okay, cool. So that's where it's gonna go.
Thank you.
And
Okay.
to clarify, are you ordering administrative cost or ongoing fine for the camper?
There is no ongoing fine. There's no evidence of an ongoing violation. The evidence is that the violations were brought into compliance.
So, can I just quickly argue that the property is my primary residence? It is not,
Oh, I accept that.
okay.
The hearing is over.
Okay, prior to this. you
Actually, I
had
take that
said-
back. Are there members of the public who want to be heard on this? I encourage that.
I actually want to say something.
Yes.
Yep.
Yep.
Ma'am? Oh. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I think. Hi, I stand here before you. My name is Carla. I'm not here just as a resident. I'm sorry. I'm so baffled about the situation. I stand before you today not just as a resident of this community, but as someone deeply invested in this well-being of my future. My partner and I have poured our hearts into this Happy Campers Rescue Ranch and a sanctuary for the animals in need, and a beacon to our neighborhood. For the years we've nurtured these animals in Haven. I can't read this.
Take your time.
Basic-
Take your time.
I mean, it is what it is, you wrote it.
Yeah, however, our efforts are now under a threat. The neighbor's complaint has led us to an unwanted fight with code enforcement despite the operations being complaint on statute 559.555. This isn't just about us, it's about everyone, every home-based business in our community that adds value to our neighborhood. Denellen is a place of hard workers and entrepreneurs and dreamers. We cannot afford to let the actions of one individual stifle our spirits of creativity and progress. We need our support to ensure that small businesses like ours are protected and valued. I urge you to consider the implications of your decisions today by standing with us. You're not just defending our rights to operate, you're upholding the principles of our fairness, justice, and community that defines us. Let us show the world what it means to support our neighbors and build a stronger community.
I actually agree with you based on the fairness, but my problem is that I have to follow what this rule says, what the law says.
I get it.
The law says that it can't see it by the road, and the law says that.
That is not what it says. And I listen, the county's brief is well-written, and I think it's really persuasive. So I think that
They have lawyer support.
if you are going to prevail, you're going to need to appeal it. And a circuit judge might agree with you. You don't need a lawyer for it. You can appeal it on your own.
I know, like.
And you guys have represented yourselves so far, so
Thank you.
thank you.
Thank you.
Anyone else before he continues?
Thank you.
Next case on the agenda, Martha L. Hoagland, case number 2193819. Officer Keith Garner, page 16 of your agenda. Experts on the case, Land Development Director Joanna Coutu and Certified Building Official Samuel Acosta.
16.
Page 16. 2193819.
Ms. Hoagland, you don't have to. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Good morning.
Morning.
And who for the record are y'all?
I'm James Hartley. I work at the law firm of Gooding and Batzel in Ocala. I represent Martha Hoagland.
Gooding and Batzel.
That's right.
No, I wish I had heard of that ahead of time. I'm kidding. I used to work for Jimmy. Back when it was Gilligan, King, and Gooding, but at any rate, it's always fun working with Jimmy Gooding.
Yeah, always.
And ma'am, you are?
Martha L. Hoagland.
All right, thank you. Y'all ready?
Good morning.
Okay, good morning.
Randall Garner, Licensed Compliance Officer, case number 2193819, Article 18, Chapter 18, Article 1, Section 18.8A. Obtain after the fact permits for all construction or modifications to Citrus County Code of Ordinances. Address is 1520 Southeast Pinwheel Drive, Crystal River, 34428. Property owner is Martha Hoagland Revocable Trust. Good service via certified mail return receipt, and I would like to authenticate the documents and request they are admitted into evidence. Exhibit A, photos taken during my initial inspection on October 17th, 2023. Photos taken during a follow-up inspection March 26th, 2024. And my corrective action inspection on April 15th, 2024. Then there's a photo of the pre-hearing inspection on May 14th, 2024. Exhibit B, a copy of the notice violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the certified mail receipt indicating good service. A copy of the shed permit finalized on March 4th, 1997, a sketch dated June 14th, 2000, indicating the location of the shed, and two other drawings showing the existing shed.
What was the first, so before the, I think you said a June 14th, 2000 document. What was before that? 1997?
A copy of the shed permit finalized on March 4th, 1997.
March 4th. Okay, gotcha.
A sketch dated June 14th, 2000, indicating the location of the shed, and the two other drawings showing the existing shed dated June 14th, 2000.
All right, so sir and ma'am, what I normally do is I ask you to look at the exhibits that they have and let me know if you have any objection to them being evidence. But before we get to that, I want to ask you, is there an argument between y'all about whether a violation exists?
Yes, there is.
Okay, all right, go ahead. And take your time. Is it Mr. Hartley?
Yes, sir.
Have you seen these documents
I have.
before today?
Yep.
Are there any objections to these documents being evidence at this hearing?
No objection.
Do you have any of your own potential exhibits?
I do.
All right, without objection, so you've got an A and a B, exhibits A and B?
Correct.
Is that it?
Correct.
All right, then without objection, what's been proposed as exhibits A and B are evidence. If you don't mind, just give me a moment to look through these before you continue. As far as allegedly unpermitted sheds go, this is one of the nicer looking ones that I've seen at the hearings. Let's see. Okay, I think I know where you're going with it. Go ahead.
On October 17th, 2023, an inspection was conducted at 1520 Southeast Pinwheel Drive, and photos were taken with a complaint of a storage building being used as a residence. During my inspection, I observed 2 sheds on the property without permit. The 10-by-10 shed has been removed and is not an issue, but the 16-by-20 shed still remains.
You said 16 by 20?
That's correct.
Okay.
It was permitted as a shed but converted into living space with plumbing and electrical. No building permits have been applied or issued for this to be a residence. Expert witness in the case is Land Development Director Joanna Coutu and Building Official Sam Acosta.
Thank you. Y'all pick?
Okay, that would actually be a change of occupancy, type of permits that would have to be issued.
Well, so it's your testimony that in order for this structure to be allowed to be used as it is, it would need a change of occupancy?
If it is indeed being used as a residential occupancy, correct.
And what would be needed in order to do that?
Well, there's a few design criteria as far as if you have a sleeping room, you can have smoke detectors, that kind of stuff. And you would also have to have what they refer to as an emergency escape and rescue open, which is a window of a certain size or a door that leads directly to the.
So that's
exit.
essentially building code compliance.
I'm sorry?
That's building code compliance stuff.
Absolutely, yes.
Well, but I guess what I mean is what would they need to do, assuming that you're right? I mean,
yeah.
what would they need to do in order to accomplish that?
Just to provide a set of plans that showed how it was modified. And if there's any portions of it structurally that we can't inspect, then they would have to also include an inspection affidavit from an architect or engineer.
Would, based on those plans, would you require another permit?
Yes,
A modified,
Yeah.
a modified permit or a new permit?
a new permit, yeah. The old permit, I presume, is closed.
Okay. Is that it?
That's it.
All right, Ms. Coutu?
Joanna Coutu, Land Development. I'm here for the waterfront setback issue. They did receive a 2,000 variance for waterfront setback of 17 feet. That was for a replacement house, the residence that's on site, and for a detached garage. So if and when they apply for a permit for this new structure, we can certainly look at that, but it was supposed to be a detached garage at that time.
Let me just slow this down. So you're saying that back in 2000, there was a variance issued for a waterfront setback?
Yeah, I'm sorry, Kimberly, I'm looking over at you.
Actually, I think the photos that are at the end of Exhibit A show the variance that Ms. Coutu is referencing. The hand drawings where they have the shed, and then they have, I believe to the right is a detached garage.
Oh, you mean Exhibit B?
Oh, sorry, Exhibit B. I know pictures help me.
I don't know if anything can help me, but, okay, so I see,
And it says proposed on the 2 proposed portions. One is the attachment to the residence, and then the detached garage would sit to the right of the shed that is the subject matter of this case.
okay, so what is,
I don't know if it meets waterfront setbacks. We'll know at permitting time.
you don't know if it meets, if what does not meet
If
waterfront?
the shed that they're talking about now, the converted.
The 16 by 20?
Right, right. If it was there in the exact same spot as before, then we're probably okay, but I don't know. And they can have an accessory dwelling unit. It needs to be 850 square feet of living area or less, so we'll be looking at that as well.
All right, so looking at the notice of violation, by the way, I need to fully understand what the county's saying before I talk to y'all. It says a storage shed 10 by 10 without permit, that's not an issue, it's already been removed. 14 by 20 storage building converted to a residence, non-compliant with coastal A zone flood requirement without a permit. So I think what I heard from Mr. Acosta was the residence issue, and Ms. Katu, you're testifying to the coastal A zone flood requirement?
No,
Yeah, you're-
that is something that he would look at as part of the building permit, absolutely. I'm looking at waterfront setback, it's in the exact same spot, then I'm not looking at, then I'm not concerned with that. They can have another dwelling unit, however, it would have to be less than 850 square feet of living area, and since we don't know what's inside right now, I don't know.
And I think, so basically, what I should take your testimony for is that it's gonna be a condition of a permit that it comply,
Correct.
assuming I find.
Correct, just saying it
Okay.
might not be a slam dunk, I just don't know until we actually look at what's happening there.
Okay, I think I understand. Is there anything? Yeah.
Yes, there's an amended notice of violation on the second.
Oh, there is. What did you amend it for?
The lawyer had
Oh,
sent in.
man,
that-
they're trouble. I tell you what. All right, so I think I understand the county's case. Mr. Hartley, I'd love to hear from you.
Yes, and I think some of the confusion comes from, we're both getting that it's a use and occupancy issue, but I believe there's also testimony concerning plumbing and electrical. And I do want to ask the county, do you believe that there was plumbing and electrical work done without a permit?
Yes, I will stand to that, yes.
And why do you think that?
There was a tankless water heater put on the building, which was permitted, but what would you need a water heater for without plumbing?
Okay, so the tankless water heater was permitted, but do you have the site plans from the 1997 permit for this structure?
The site plans, yes, I believe there's some site plans in the case,
Okay,
which do not include any of this. And as far as electrical, there's an AC that is installed in the upper photo of one of the shed, and that AC would not be there if it did not have electrical.
okay, but you don't know if that electrical and that plumbing was approved in that 1997 permit?
I did not see that, right.
So you don't know that?
I did not see that. It was installed as a shed at that time.
Okay. But just to confirm, you did agree in the affirmative that you do not know if electrical and plumbing was permitted at that time?
I don't believe it was.
You don't know if it was?
Correct.
All right, so the other issue that we have is the use and occupancy, is that correct?
Correct.
Okay. I'd like to go ahead and submit the exhibits that I have that I think will help with cross-examination. They're responding to exhibits A through X.
This is my copy.
Yes, sir.
Do you have a copy? Is that the only other copy you have, or?
I have 3 copies, one for myself and one for.
So the county should feel free to share what's been provided to it, to the county attorneys, if they.
Can we see that
Keith,
first, please?
come here.
Thank you.
Stay here.
While we're waiting, is there anyone from the public who's going to want to be heard on this case? Okay, thank you. I just need to know that ahead of time. Just so the county knows, I'm not sure these are all at issue yet, so I'm not gonna take objections before he gets to them, if that makes sense. And I won't look at the exhibits either, but I will look at the case law. I'd like to let Mr. Hartley continue with his examination. I'm not sure all these documents are at issue yet. Yeah, they're not under an obligation to provide separate copies, to be honest. That was nice of them that they gave me a copy.
Are you going to be asking specific questions about these documents?
I'm going to start with Exhibit C, D, E, and F, which are the permits, G, which is the variance, and then some of the Land Development Code, which is K, L.
All right,
And,
I'm not inclined to, I'd like to let you continue your examination.
Okay.
Yeah.
Thank you.
Are you gonna, but you're not gonna, you've gotta, this is his copy.
I know, that's why I'm having to go back to him, but
Yeah.
I have your copy here. Here. It's not in evidence. No, there's no.
Okay, Mr. Hartley, please proceed.
I'd like to first start with Exhibit C, which was also included as one of the county's exhibits, but I'll introduce or admit into evidence as Respondent's Exhibit C, which is the 1997 permit for the site-built shed.
This is already in evidence, correct?
Correct.
Yeah, all right.
We would just object that it be cumulative and it's not needed to be entered at this time.
So in that permit, you can see that a permit was pulled to build this structure. I believe at the top of the type of permit, according to the details, it just says building history. Then it's in the description of work, it says shed site build 14 by 20. Next, I'd like to turn to Exhibit D.
Well, wait, so are you going to, Mr. Hartley, are you going to be asking questions of are you in cross-examination, in other words?
I am, and what I'm doing is I'd like to see how the permits for this property were described and then get into the questioning.
Well, what I want to do is just ask your questions.
Okay.
And then you can make argument based on the exhibits to the extent I admit them.
Okay, so turning to Exhibit D, would you agree that the permit details just say that it's building history?
The description of work,
This is an examination of Mr. Garner. Who are you examining?
Mr. Garner.
Okay.
What is your question?
So Exhibit C,
Exhibit C, all right.
the permit type, what's listed there?
You're saying under building history?
Yes, the type is just building history, correct? It doesn't say shed,
No, it doesn't.
doesn't say storage only?
No, it doesn't.
Okay. Under the description of work, could you read that to me?
Shed, site built, 14 by 20 with 1131 square feet, 4-inch slab revised. Owner was originally issued permit for prefab shed and decided to change to site built revised 117 from prefab site to built shed, to site built shed.
Okay. Could you turn to Exhibit D, please?
I'm going to reserve ruling on Exhibit C. It is already admitted in evidence. Go ahead.
Thank you, Your Honor. I'd like to, or could you tell me what permit Exhibit D is?
Gas, fuel, chemical storage.
Okay, to your knowledge, is this for the parcel at issue?
It was for the main house and added the shed,
Okay.
as in the drawing.
I just want to make sure I understand your testimony. So based on your review, this document that they're going to seek to admit it pertains to the main house, and then it also pertained to the
Shed.
site-built shed?
Correct.
Okay.
Okay, could you turn to the,
Are you going to seek admission of this?
yes, Your Honor.
Any objection? All right, it's admitted. And by the way, so what I'll do is, I'm just going to keep your numbering. This is going to be Respondents D.
Thank
Okay?
you. Could you turn to the 6th page of Exhibit D? At the top, it says site plan.
I'm there.
Yes, I believe you're looking at the right one. Could you see, this is a site plan that would have been submitted to the county
Correct.
and approved by the county?
I don't see the approval on this.
Okay, but you do agree that this work was done and approved?
It was permitted.
It was permitted. And on that site plan, the structure that we're talking about was referred to as a cottage?
Previously referred to as a shed. It was written in here as a.
But on
cottage.
the site plan that was approved, it was submitted as a cottage?
Yes.
Okay. Could you please turn to Exhibit E? I'd like to enter.
Roof permits.
Yes. I'd like to enter Respondents Exhibit E into evidence.
Well, first, if you don't mind, lay the groundwork for
Sure.
it. I don't know why it's relevant yet.
Okay. Mr. Garner, could you please tell us what Exhibit E is?
Roof type permits.
Okay, and could you read the description of work for me?
Re-roof cottage.
Okay, and this is a permit that was issued?
That was issued, correct.
Okay.
Now, I have a question of Mr. Garner. So both in terms of the last exhibit, which was Respondents Exhibit D, as well as this exhibit, which may or may not come into evidence, have you seen these documents before?
I have reviewed these permits, yes.
Okay. And in your determination, these weren't relevant for my determination of the county's case?
I didn't believe so
Okay,
because there were permits that were pulled and issued. And, well, I won't speak on this. Go ahead.
Well, I don't know the answer myself. I'm just curious. I want to know where the county's coming from, so that helps me understand. Are you now seeking admission?
Yes, Your Honor.
We would object for relevance.
What is the relevance?
I believe it shows that the county has approved subsequent permits that, in which this has been referred to as a cottage.
Okay, I'll admit. Respondent E.
And we would object.
Yep, overruled.
And could you please return to Exhibit F, please?
Repair, remodel, rehab, alter, damage.
Okay, and do you know what this permit is for?
Replacement of 28 windows, flood zone.
Do you know if
Pre-firm structure, not substantial improvement, elevations verification not required.
do you know if this was for both the cottage as well as the main house?
Well, you can't put 28 windows in a 16 by 20 shed, so I would say it was for the main house.
Okay, do you know if it was for the cottage as well?
I do not know.
And again, my own question, I reserve the right to ask some. Is there any way that you would be able to tell one way or the other on this document?
You typically would apply for 2 permits for 2 separate structures.
Okay.
I wouldn't issue a permit to encompass more than one structure because it invites the confusion.
Okay.
But do you know one, I understand what you would be your typical practice.
Correct.
Were you in charge of issuing them at this time?
Absolutely not.
Okay, I didn't think so. I didn't think so. So, all right, I appreciate that. Mr. Hartley, go ahead. So are you now seeking admission, or do you have other questions on this document?
Because we couldn't get testimony at this time as to whether it applied to the cottage as well, I don't think I would be able to admit it for it not being relevant.
It's up to you. Okay.
Could you please turn to Exhibit G? Do you recognize this document?
This was an application for variance, maybe?
Okay, and I think you would recognize that it was also one of your exhibits. But-
Exhibit G?
It's Respondent's Exhibit G, but I believe it was admitted as a county's exhibit as well.
This was from 2000.
Did they not?
The drawing of the house and the shed. Sixteen by 20 shed. The drawing was in there, but not the variance.
Okay. Then I would like to, this is a variance for the property at issue?
Correct.
Okay.
I'm not sure if it was issued or not, but it's there.
Okay, so I'd like to enter Respondent's Exhibit G into evidence.
No objection.
Okay, admitted.
On the first page there, could you go to the third paragraph that starts on the basis? I'm not, yeah, this variance doesn't concern me.
You admitted it as part of your case, didn't you?
Not this, no,
Oh, okay, I thought,
just the drawing.
I received it from the county as exhibits that they may enter. I don't know if it was,
If I may speak, the drawings were part of his exhibit, what he's, I believe, referencing, because I don't see it in front of me.
Okay.
I don't believe the document where he's
Okay,
asking
'cause
for
I haven't seen
paragraphs
this.
from
Okay.
is, I think that's where the confusion
all right.
lies.
So it looks like they entered a part of it, but not the whole thing, and that's why, but they're not objecting to the entry. Yeah.
So I believe the Respondent's Exhibit G is entered into evidence, and I'm asking you to read the first page.
I mean, I can
paragraph
read it myself.
Okay.
I mean, it's part of the record.
Sure. And the point that I'm trying to make here is that this was a variance for a residence with a detached garage, and it was referred to as a detached garage here.
You're leading up to an equitable estoppel argument.
Not yet,
Okay,
not yet, if we have to get there.
okay.
What I'm leading up to is that these documents have been, and I'm getting in, actually, I'll take a step back at this point. Can we please turn to Exhibit K, please?
And so the county is aware, just let me know if you need to see something before I render a decision on admission, and I'll take the time to let y'all see it. This is just a copy of the code.
Okay.
And
I was actually about to ask to see what it was.
It is, this copy of Section 2403 of the Land Development Code.
2403.
I mean, I'll make this easy. Exhibits KLM. Are all admitted.
Thank you, Your Honor.
And what are KLM?
Land Development Code Section 2403 is Exhibit K. Exhibit L is Land Development Code Section 3101 and 3102. Exhibit M is Land Development Code Section 2300.
I'd also like to call attention that both of these, the drawing was showing a 16 by 20, and also the other drawing was considering it as a shed.
The county will have an opportunity to do that when it's its turn.
Thank you. Do you know what the property is zoned for?
No, I do not.
Okay.
Flood zone is the only thing I was looking at.
But as far as its zoning designation?
I do not know.
Okay. But on coastal and lake residential units, an accessory structure is allowed, is that correct?
Land development says yes.
Okay. If we could go to Exhibit L, please. Which has been admitted into evidence already. Would you agree that the structure has been referred to by multiple things? It's been referred to as a shed, it's been referred to as a cottage, it's been referred to as a detached garage?
The permit stated a shed, and it was never referred to by us as a cottage.
Okay, but in the other documents and permits that have been approved by this county, they have been referred, or site plans have been shown it as a cottage?
Drawn up site plans, yes.
Description of work has been referred to as a cottage?
I did not see that where it was referred to as a cottage, but it was on the drawings.
Okay. In the variance, it was referred to as a detached garage?
Yes,
So all of these things are accessory structures, correct?
no argument, correct.
All right, under 3101, which is Exhibit L, they have a list of accessory uses that may include but are not limited to certain things. Would you agree that Section G there allows for guest cottages and garage apartments as accessory uses?
Guest cottages, garage apartments with living units, accessory dwelling units having 850 square feet of living area or less, or non-commercial occupancy only. Only one such unit is allowed per residential site.
And what were the dimensions of this property?
Just say again?
What are the dimensions of this structure?
16 by 20 according to the drawings.
Okay, so it'd be less than 850 square feet?
That's correct.
Okay, you don't have any evidence that this was used for any commercial purpose?
No, I do not.
Could we please move to Exhibit M, please? Let me back up. Can we stay on Exhibit L, please? But to 3-4 at the bottom of the page, going to Section 3130. Oh, I misspoke again. I apologize. Moving too quickly. Some would disagree in this room. All right, if we go to 3-3, Section 3102. At the top, you would agree that the Land Development Code says that all accessory uses, regardless of location, shall be allowed once a permit is issued and meets the following requirements. Is that correct?
Once a permit is issued, and this is also land development, so.
Okay. And going to Section A there, it says accessory uses and structures may not be placed on residentially zoned property prior to the established principal use. There was a principal use for this property prior to the issuance of this accessory structure?
Not aware of that, I'm not sure of that.
So you don't have any evidence that say that it's not?
I did not say that.
Okay. Going to Section B, you would agree that it says that accessory structures shall not be occupied as a residence, with the exception of a guest cottage, accessory dwelling unit, garage apartment, as outlined herein.
All right, you're on B,
I am.
and which one are you looking at there?
I'm just asking if you agree that this is the Land Development Code's language.
I'm not land development code.
But this has been admitted in the evidence. Do you deny that this is the Land Development Code?
I am not land development code, I'm dealing with the licensing side of the.
That's not the
permission.
question, though, but do you deny that this is the Land Development Code?
I don't know if this is the most recent land development code.
Okay, do you see the date at the bottom? What is that date?
November 28th, 23.
Are you aware of any revisions that have been made since then?
I am not.
Going to C, all accessory uses and structures shall comply with the development regulations and applicable to the land use district in which they're located. You don't know if this violates that, do you?
No, I do not.
Okay. You don't know if this violates any setback requirements?
No.
And you would admit that this isn't a vehicle or a trailer or a manufactured house, shipping container, or similar unit?
It is a site-built shed.
Okay, thank you. All right, I have no further questions right now.
Okay, so just to be clear, you've given me a binder with, it's not your intention to go into any of the other exhibits that you have? Or do you have other witnesses?
I don't plan on doing it on these cross-examination.
Okay, all right.
If we.
No, that's fine.
And at this time, I would ask that this, oh, please,
Can I redirect?
You can.
Or if we're done, I don't want to cut you off.
my apologies.
Okay. Mr. Garner?
Yes.
All right. Going back to a few things, we're going to, I'm just going to work a little bit backwards from his question.
Certainly.
He had you looking at 3101. I believe that was his Exhibit L.
No. 3101, residential accessory uses, yes.
Are permits required for a residential accessory use to be on the property?
Yes, it is.
Is a shed a residential accessory use?
No, it is not.
The variance referenced as his Exhibit G.
Okay,
The photos, the hand drawings that were admitted at the back of that evidence, but were also part of your evidence. Can you please turn to that?
correct?
Is there a hand drawing of the residence on that image?
Yes, there is.
To the right of the hand drawing of the residence, is there a shed?
Yes, there is.
To the right of the shed, is there a second square that says proposed building?
Make sure I'm looking at the right one. Okay, this one. Right, I'm on there. Proposed building, yes,
Okay. And it's separate from the shed?
correct.
Okay. Going to his Exhibit D, which was the gas fuel
The permit, yes.
permit, you referenced that the shed was included there. Looking at that permit, was anything other than the water heater permitted as part of the shed?
The 2 gas tanks, 2 water heaters, 1 cooktop, 1 generator installed. Electric for generator permitted, and tanks to be anchored, engineered specific to elevation, certificate not required, yeah.
And when you look at the drawing that was provided as part of that,
Right?
you mentioned cooktops and all kinds of other interior things. Are those referenced in the shed drawing, or are those referenced in the residence portion of the drawing?
Only the main resident.
Okay.
Wait, I want to make sure I understand what you just asked about. Are you asking whether those gas lines go to the house or the shed?
Correct, that the only item that is permitted as part of the shed and attached to the shed is 1 water heater, and that's it. Everything else, residential interior, is part of the actual primary residence.
And was the electrical a part of that water heater installation?
Negative.
Okay.
It was speaking about the required electric for generator permit. That deals with the generator hookup to the main panel, whatever they were operating there.
So you can tell from this document that to the extent that there is a water heater permitted for the shed, you
Correct.
can tell that it doesn't include any electrical work.
Correct. Well, the electrical, right, it's showing electrical for the generator.
Would there be a presumption that if you're
Separate permit.
permitting the water heater, that it would be serviced by electrical on the shed?
Well, because it's a gas water heater, it only requires low, like 120 volts for the screen to be operated to set your temperatures and things like that.
I mean, you have to unfortunately talk to me like I'm a kindergartner. So does that mean that it wouldn't need any additional electrical permitting in order to function?
It would,
Yeah,
it ignites it, for one.
Okay.
It ignites the gas.
So without seeing anything, if this is all I saw, it's your testimony that I wouldn't be able to tell whether or not the electrical was permitted for the water heater or not.
I do not see that it was permitted with the water heater being installed and the gas tanks being installed, it would not have been done on this permit.
Okay.
On the document you're looking at now, I believe that's the one where, on the site plan, it's handwritten in the word cottage, where the shed was
Correct.
permitted. Who fills out that site plan? Is it the county?
No, it's done with whoever does the drawing.
So the owner or the builder?
Correct.
So you testified that you had seen these permits previous to today,
I
correct?
had researched these, yes.
In your research, did you find any record of an inspection of electrical specifically for the shed?
No,
And in your research, did you find any record of an inspection specifically for water plumbing?
no, I haven't.
No further questions.
One of the obvious questions that I missed is why do you believe that this is being used as a residence?
It was admitted to be by Ms. Hoagland on October 17th when I stopped at her house.
Okay, and what was that admission?
I asked her if it was being used in an office, being that it would be a business, and she says no, her son was living in
Okay,
it, which is in
and
my log notes.
did you make contact with her son?
No, I did not.
You did not make contact with her son?
I only spoke with her.
Okay. All right. The gas lines, though, they do go to both the cottage and the main house?
Correct.
Okay. Another obvious question I may have missed in the first go-around is why do you believe that this is just a shed storage only? What makes you believe that?
In 1997, it was permitted as a shed and not been changed to a residence.
Okay, and you base that off of the description of work in Exhibit C, which is the 1997 building permit?
Correct.
Okay.
And all the work since then had been done with the house,
Okay.
the tank and the windows.
And speaking of that work, so the only reason you believe it was originally permitted as a shed only is because of the description of work in the permit detail?
Correct.
And the description of work in the permit detail of the Exhibit E, Respondent Exhibit E 2019, says that it's a re-roof of a cottage?
Correct.
Okay. I don't have any further questions.
This permit was also pulled on a, what do you call it, when they expedite the permit? What is that? When they need a permit, like right away to re-roof?
Emergency repair.
Yeah, it's
maybe?
just a,
Yeah.
yeah,
Alright.
it was permitted as emergency repair, which means that they wouldn't have seen anything put into.
Do you have any personal knowledge of that?
I was told that by a permit tech when I
Okay.
asked her about it.
Could you please repeat that? What was told to you by permit tech?
That the re-roof was put on a emergency permit, meaning that there was no drawings or nothing turned in until after the re-roof had started.
Okay, but that's not shown on the permit details?
That was on, right, it was in our old system, but to know that, no, you would not see that in
Okay.
the permit, because it was pulled after they had started the roof.
Do you have any other witnesses?
No, just some brief argument for why this should be dismissed.
All right, I will entertain that argument.
Yeah, so the,
And then I'll hear from the public and hear from the county.
okay, I don't believe that the county's presented a prima facie case that there's a violation here. They have admitted that they do not know if there was any electrical or plumbing there. We have several permits that were all pulled for this. They cannot pinpoint any specific construction that was done to this structure that was done without a permit. As you can see from the multiple permits here, it appears that everything was done with a permit. As far as the use goes, I believe it's clear from the Land Development Code that this was an accessory structure. The allowable uses for accessory structures were listed there, which include a garage, it includes a carport, and includes a dwelling such as this that met all the criteria for a cottage dwelling or a garage apartment.
Does that complete your argument?
Yes, sir.
I'm going to reserve ruling on it. I'd like to hear from the public. Is there anyone from the public who wishes to be heard? All right, ma'am. Could I ask you to come up, and I don't know what podium will be appropriate.
And I'll let her have this podium. And just to be clear, that was just the cross-examination.
I totally understand.
Okay,
That's
yes, sir.
why you moved to dismiss it without presenting your own evidence. I get it.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name?
My name is Diane Elmhurst. I live right next door to Martha, and we moved in 2000. And when we moved in, the house was there and the cottage was there. And it's always been a living area. The previous owners, Martha didn't buy it until, I think it was 2015 or 16, but the previous owners periodically had people living there. So when Martha bought the house, I thought that this was the perfect fit because she has a son that's disabled. He's on the autism spectrum. And so this is a perfect place where he can have his independence and still be in a safe environment. So I just want to classify it that in the neighborhood, it's never been a problem. It's always been a cottage. People have lived there.
All right, I appreciate that. Thank you, ma'am.
You're welcome.
Is there anyone else from the public who wants to be heard on this case? Okay. Let me take a moment just to think about the motion. Well, is there a response from the county to the motion?
The county does believe it's met its burden in this case. The evidence before Your Honor is that a permit is required for a cottage, that it was permitted as a shed, that according to our building official, in order for it to be converted, a specific permit would have to be pulled for it to be converted. While Mr. Hartley has put in a number of permits, putting in gas lines, putting in a roof, putting in windows in a primary residence, no matter how you refer to the building, whether you call it a shed or a cottage, doesn't magically convert it from a shed to a cottage. We would fully expect somebody who has a shed with a rotting roof to replace it. So those types of permits only go to show that this homeowner knows how to pull permits, knows what she needs to do to be in compliance with the county code. It just clearly hasn't been done in this case, and we think she needs to abate this by applying for the permit to convert it.
All right, I'm going to read the code section real quick. Okay, I'm going to deny the motion and let you proceed with your case. And just curious, do you have any idea how long you might take?
I believe we're just going to ask a few questions of Ms. Hoagland. I would guess 20 minutes,
Okay.
If there's going to be no further questions of the county, can I have the binder, please?
please.
All right, please proceed, Mr. Hartley.
Thank you.
Ms. Hoagland, you purchased the property in 2015, is that correct?
Yes.
When you purchased the property, it had the main house, a cottage, and a shed on the property, is that right?
Yes, it did.
Okay. And when you purchased it, were you under the impression that everything was in compliance with all the codes and the law?
Yes, according to the seller's disclosure.
Okay, and you're getting a little ahead of me. Let
Sorry.
me get there first. But the first thing that you relied on, though, was the MLS listing agreement. Is that right?
Yes.
All right, I'm turning your attention to Respondent's Exhibit N. Is this a copy of that MLS agreement?
Yes, it is.
All right, and among other things within the public rems here, you'd agree that it says that it was advertised as having an adorable guest cottage that features a full bath and loft bedroom. Is that right?
Objection, hearsay.
Overruled.
That means you can answer.
Yes.
Okay. And you relied on this document?
Yes, I did.
Other documents that you relied on were the disclosures that I believe you were getting into. Is that correct?
Yes.
Well, I would also like to admit Exhibit N into evidence.
We would object.
On what basis?
Improper foundation.
It overruled, it's admitted.
Okay. What is Exhibit O here?
I have a question about it, though.
Yes.
So my question is, Ms. Hoagland, is it your testimony that you actually reviewed this document before purchasing the property?
Yes.
And is this is a copy of a page on the MLS?
This was the printed off copy that I printed off for myself.
How did you have, I mean, I'm just curious, but how did you have access to the MLS?
My realtor gave it to me.
Okay.
This was in my historical files.
Okay, thank you.
I'd like us to turn our attention to what's been marked as Respondent's Exhibit O. Do you recognize this document?
Yes.
And what is it?
It's the seller's disclosure.
We're talking about O?
Yes.
Well, page 1 says it's the
Lead base.
lead-based paint disclosure.
And then it has multiple pages,
Correct.
including the seller's property disclosure. And if we could just move to the fourth page, section 9. What is this section?
Section 9 is the governmental section.
Okay, and was this provided to you when you purchased the house?
Yes,
And was it signed by the previous owner of the house?
signed by the previous owner and myself.
Okay, and just generally speaking, in here, they asserted to you that there's no zoning restrictions,
Yes.
no code violations,
No code violation.
no flood area or base flood elevation issues
Yes,
or violations of the local guidelines?
yes,
Okay, and you relied on this in purchasing that property?
yes, I did.
All right. I'd like to admit Respondent's Exhibit O into evidence.
The county's position on Exhibit O?
Your Honor, we would object to it not being relevant in this matter and full of hearsay.
Hearsay is not a basis for an objection in a quasi-judicial hearing unless the fact finder makes a decision or a key finding as to an element based on the hearsay, so that objection is overruled. I find it relevant if relevance is an adequate objection due to the fact that it may be relevant for my determination of a fine as well as for a potential equitable estoppel argument. Overruled. And it's admitted.
And turning to Exhibit P, what is this?
Uniform residential appraisal report.
Okay, and is this something you also relied on in purchasing the property?
Yes.
Going down to the fourth section entitled Site, could you give me a general explanation of what this says?
It says that they reviewed the property for zoning compliance and said it was legal. They also reviewed for electricity, water, sanitary sewer, FEMA special flood hazard. They said yes. Are there any adverse site conditions or external factors, easements, encroachments, environmental conditions, land use, et cetera? And they wrote no.
Okay. And do you know who prepared this?
Mr. Lowry.
Okay. And in reviewing this survey, did you get a understanding? He's someone who used to work for the county?
Yes, he worked for the county from 1995 to 1998 in his qualifications.
You said survey. Did you mean appraisal?
I did. I
Okay.
apologize if I said survey.
And is the highlighting in the site section part of the original, or did you highlight those?
That was added.
Okay,
Yeah, I highlighted.
okay.
All right. I'd like to admit Respondent's Exhibit P into evidence.
Position.
We would object based on foundation. This is a professional report that she has no knowledge of.
Overruled, it's admitted.
Do you have flood insurance on this cottage?
Yes, I do.
Okay. And when you purchased the cottage, did it already have electricity?
Yes,
Did it have running water?
yes, it did.
Loft bedroom?
Yes,
Full bathroom?
full bathroom,
Kitchenette?
kitchenette.
Does it have a cooktop surface?
No,
Does it have a washer and dryer?
no.
You did make some improvements to the cottage, correct?
Yes.
All right. Tell me about the what's been admitted as Exhibit D, the 2016 permit for gas lines. What was that? Tell me a little bit more about what that was for.
Okay, so that permit was drawn by Anderson Gas and Premier Electric. The gas lines were installed in the cottage and the house. The tankless water heater was put on the outside of the cottage and a tankless water heater in the house. The generator was installed to encompass and run the whole house and the cottage.
So the generator lines were run to the cottage as well?
They're all interconnected into the box.
Okay. And you had mentioned you had to tie down the gas tank?
I guess there was an engineering study done that said that there had to be straps on the tank. And if I recall correctly, the permit shows the engineering design.
Okay, and I'm showing you what's been marked as Respondent's Exhibit Q. This is a picture of the tied down gas tank.
Yes, it is.
Okay. I'd like to admit Exhibit Q into evidence.
Position?
No objection.
It's admitted.
All right. And you'd mentioned you also had the generator installed,
Generator was installed.
and that had to be lifted.
Yes.
All
Had
right.
to be elevated.
Turning your
I'm
attention-
sorry, so is it the testimony that when you bought the property, the generator was there?
No.
Oh,
I
okay.
had it installed.
And you said it had to be
It
lifted,
had to be elevated.
so in order to be installed, it had to be elevated?
Yes.
Okay, thank you.
Okay, and I'm turning your attention to Respondent's Exhibit R. Is this a picture of the elevated generator?
Yes.
Both pages?
Both pages.
Okay, I'd like to admit Exhibit R into evidence.
County's position?
We would object to relevance.
I'm kind of curious.
I think this just goes to show that all of the steps that she's gone to, that flood considerations were taken into consideration when she did this, and showing that she did have to make that elevation at that time.
I just don't see how it's relevant. I understand, but how is that relevant for your case or defense?
It's going to all the work that she's put into this property.
All right, I'll admit it solely for the purpose of potential mitigating damages and fine amounts, if there is any. Yep.
Okay. And you recall having all of these issues inspected?
Yes.
And do you remember who inspected that?
A Mr. Rupert inspected it
Okay,
on 9/27/2016.
okay. All right, and passed inspection after
Yes,
having
I
to
was
raise it?
there when he inspected it.
Okay. And then, moving on to other improvements you made in 2019, as we discussed, you had to put a new roof?
I put, it was a re-roof of the cottage, and it was not an emergency re-roof.
Okay, and in your application for that, you referred to it as a cottage?
Yes,
Okay. And there were no issues given to you at that time?
no,
Okay. And in 2021, you had to get new windows, is that correct?
yes, I installed new windows. Sorry, I didn't hear her answer. Oh, I installed new windows.
Okay. And turning your attention to Exhibit F, is this a permit for those windows?
Yes,
Okay. And were those windows for both the main house as well as the cottage?
yes,
That got properly permitted?
properly
You
permitted.
informed them that this was for the cottage?
Yes,
And it was all approved?
the permit actually listed it as an apartment.
Okay. And I don't believe Respondent's Exhibit
I
F.
don't think so either, but my question, we're talking about Exhibit F, and we're talking about 28 windows?
There are 28 windows.
And where are the windows?
24 are in the main house, and 4 are in the cottage.
Okay, thank
Okay.
you. And are you seeking admission of this document?
Yes, Your Honor.
What is the county's position?
We would object to relevance again like we did the first time.
I'm going to admit it.
And we've gotten into it a little bit, but could you describe the interconnectedness of the utilities between the main house and the cottage?
The electric to the cottages run from the main house. The water sewer lines are connected to the main house. So it's, the electric runs from the cottage actually to the dock, and that was original, apparently with the house. So everything is interconnected in that their sewer lines are connected in, the water lines are connected in, the electrical, the main circuit breakers are in the main house.
So Is that why when the water heater was installed, it wouldn't have needed separate electrical work? Or did it have separate electrical work?
It had to have, the water heater is plugged in, if you look at the pictures, into an outlet. And I believe that they did put that in when they installed the water heaters.
Okay,
And Mr.
that
Rupert
explains a
saw it.
lot.
Yeah.
Okay.
Okay. And turning our attention to your first encounter with code enforcement, could you tell us a little bit about that?
My first encounter with Keith Gardner, my first encounter with Keith Gardner actually occurred on June 26, 2023. I was returning to my residence on that afternoon from the post office. I pulled up in my golf cart. Mr. Gardner said, "Nice ride," and I could tell my son was visibly upset. He asked me, was the cottage used for business? I said no. He asked, what is it? I said it's a cottage. And he goes, how long has it been here? I said, well, when I bought the property, he questioned me about the shed, the 10 by 10, but it was actually 10 by 14. And I said it was here when I moved here. He asked me, are there straps on the shed? I said, I don't know. I didn't even know what that meant. So he handed me his business card, and it said anchor shed and space above floodplain. I gave him my email address and told him to please contact me if he wanted to discuss further. I told him I had gotten cottage permits for the cottage when I bought the property. I told him when I bought the property. And so at that point, he said he would follow up with me. After he left, I was calming my son down, and he said, Mom, what if he's an imposter? And I said, I'm going to call him right now. So I called him on June 26, 2023, and I asked him, did anyone complain? He said, no. Then I said, well, please follow up with me. Please look at all the permits that were pulled. And he said he would. I never heard anything from him, so I assumed there were no issues. And I received a signed code enforcement letter on November 24th, 2023. And I will say this, I never met him on October 17th. I happened to be in Kentucky.
All right, thank you. And on October 26th, you said when you pulled up, it was Mr. Garner and your son?
June 26th.
My apologies, June 26, 2023. It was Mr. Garner and your son who were out there?
In the driveway,
Okay. And you've had an opportunity to speak with your son, correct?
yes.
When Mr. Garner made contact with your son, where was he located?
He was in the main house.
Okay. And did Mr. Garner seem aware of any of the previous permits that we've shown here today at that time?
No, he said he would go back and research them.
Okay. And did he ever get back to you?
No.
Okay. So when, to kind of summarize this, when you purchased the property, it's your understanding that it came with the cottage and shed.
Mhm.
You haven't done any construction to the cottage without a permit.
Absolutely not. I've done nothing.
And as we've discussed, who lives in this cottage?
My son,
I don't want to get too personal, but your son has a medical condition?
yes, he's on the autism spectrum.
Okay. And does, how old is he?
He's 30 years old.
Okay. Do you help him with his medical condition?
I protect him.
Okay. But as an adult, does he desire and need to have a little bit of independence of his own?
Yes,
Just having him live in the cottage help with that?
yes, it does.
But he doesn't necessarily do all of his living in the cottage?
Right, he cooks his meals in the house, he does his laundry in the house. We have family time.
Do you charge him rent?
No,
Do you carry on any commercial or business activities in the cottage?
no,
All right. Prior to today, has anyone from the county explained to you exactly what modifications would have been needed in order to bring your property into compliance?
no,
Okay. And we've established that there was a violation issued to you for both the cottage as well as the 10 by 10 shed?
yes,
And we would agree that that 10-by-10 shed was never permitted after looking into the records,
Yes,
correct?
it was not permitted.
Even though when you purchased it, it was your understanding that it was?
It was there, so I didn't even worry about it.
And in the disclosures, it said
Yeah.
there was no issues?
Right.
Okay. So what did you do about getting the 10-by-10 shed into compliance?
I went, actually decided that I would go and pull it after the fact permit, and I actually went to the permitting office here on April 2nd, and I was told that I was needed an easement agreement or go to the Board of County Commissioners to get a variance. The lady I met with, her name was Donna, and she provided me with, first she asked me, how well do you get along with your neighbors? And I said, well, I think I get along with them pretty well. And she said, well, if you would get your neighbor to sign this, then we can move forward with getting an after-the-fact permit. My neighbor did sign it, it's notarized, and it has been filed as a record. And I came back on April 9th with the template permit totally filled out, and that it had been actually recorded. And I was able to get the same person again in the permitting office, Donna, and I showed her the document, and I said, okay, what are my next steps? And she said, well, you got the wrong one filled out. I said, well, this is what you gave me to fill out. And she said, no, it isn't. I said, yes, it is. And so then she came back with another document, and I said, well, the one you gave me is from 2020, and the one you're giving me now is from 2017. I don't understand, the versions are wrong. So we went ahead, that subject got dropped, and went ahead and I pursued, I said, so what are my next steps to get the shed permitted? And she said, well, you're gonna have to elevate it. And I said, well, how high? She goes, 6 feet. I go, how am I gonna elevate a shed 6 feet in the air? And then she said, I said, well, what if I get a new shed? She goes, well, then you're gonna have to have engineering studies, you're gonna have to have flood. And I was like, well, this is impossible. I can't even, the functionality of a 6-foot blocks up in the air with a shed is just not reasonable. So at that point, I said, well, what do I have to do can I remove it or demolish it? And she goes, well, you can do either. And I said, well, do I need a permit to remove it? She said, no, you need a permit to demolish it. So that day, I had been in communications with a shed company, and I actually called them, and I said, would you please, will you take the shed? And they go, yeah, we'll take it, and because they'll resell it. And they removed it for free because I wanted to meet the deadline that I had been given to have it removed by April 12th. And it was removed on, I believe, the 9th, the very same day that I went to the permitting office. And I have a receipt for that.
All right. Thank you. And I would like to turn our attention to Exhibit V. Exhibit V is a letter from my office to Code Enforcement dated April 10th, 2 days prior to when the shed needed to be removed, explaining that the shed has been removed and attaching pictures of the same as well as the invoice for the removal of that 10-by-10 shed, and I'd like to enter that into evidence.
Object as not relevant because we're not here as to the second shed. Testimony by Mr. Garner stated we're not proceeding on that issue, and secondly, attorneys can't testify, and this is a letter from his office.
I'm going to admit it for the sole purpose of considering it if there is any kind of a penalty.
Thank you, Your Honor. All right. And you did hire me, correct, after you got the code enforcement violation?
Yes, the October 17th letter that arrived the day after Thanksgiving. I don't know the exact date. I signed for it, the 24th, I believe.
Okay, and you're aware that I, on your behalf, have had and have attempted to have several communications with the county to try and resolve this situation?
Yes.
Okay. And you're aware that I've sent several letters to the county requesting additional information.
Yes.
And do you know if we've received any explanation on how to cure this?
No detailed explanation on how to resolve it.
Other than getting an after-the-fact permit,
Yes,
even though it's your understanding that everything that's been done was properly permitted prior to?
yes,
And the last time you tried to get an after-the-fact permit, you were told to raise a 10-by-10 shed 6 feet into the air?
on concrete blocks, yes,
And you were told that the form easement agreement that you had been given when you returned it was the wrong easement agreement?
yes.
I have no further questions, would just like to make just a slight argument.
I have to allow the county to cross
Of
if
course,
they
Your Honor.
wish.
My apologies.
Sorry, Your Honor, I'm trying
It's
to get
okay,
to the.
I understand.
Okay, turning to Respondents Exhibit N as in Nancy, do you have in front of you?
Yes?
Did you prepare that document?
No.
Do you know what evidence or information was relied upon in the creation of this document?
It was the information that was supplied to me as a part of the MLS listing by the property.
That wasn't my question. My question was, do you know what information was relied upon in the creation of this document?
I believe the realtors obtained the information,
But do you know what information that was?
whatever's listed here.
Turning to Respondents O. Do you have it in front of you?
Yes.
Did you prepare that document?
I did not prepare that document.
Have you filed any litigation against the seller in regards to this matter?
No, I have not.
Turning to Respondents P. Did you prepare that document?
No, I did not.
Do you know what information was relied upon in the creation of that document?
The information that Mr. Lowry researched.
No further, oh. Do you know what he researched?
Basically what he wrote in the document.
Do you know if he wrote anything in the document as to his sources of information? I mean, do you know without reading it?
No.
Okay, now,
no.
would reviewing it help you determine whether or not, what his
had-
sources were?
I remember recalling that he used the FEMA map dated 9/26/2014 and the FEMA map number. And I would have to look again, but I thought I recalled reading that he actually looked up the records.
But if
county
there are
records.
sources, you would understand them to be in the document or
Yeah,
described?
absolutely.
Okay.
Yes.
No further questions.
Your Honor,
Yeah.
may I add something? Throughout all this,
Actually, hold on a second. I have to allow, is there any redirect?
No, Your Honor.
Okay, then before arguments, what I'm going to ask each side is if they have any other evidence that they wish to present. First, I'll ask the county. Does the county have any?
Can I find out what it is? What it
Yeah.
is? Come here. Come here.
They may not
Come
want
here.
you to, but I'll give both sides an opportunity to complete the record. Does the county have any other witnesses?
Go ahead. Yeah, just.
Back on the record put your name back on the record for the court reporter.
Sam Acosta.
If I may, Your Honor, I know it's a quasi judicial hearing, but I would object as the county has already presented their case in chief and for equal purposes here has rested their case.
No, I allowed you to ask questions that you had forgotten to ask in your direct, and I did that so that you'd be able to lay your record, and similarly, I'm gonna let both sides present what they need to present.
Yes, Your
Go ahead.
Throughout all the testimony I've heard on this case, I did not hear any mention of the fact that an air conditioning unit was installed. And so you would be taking unconditioned space and conditioning it. That would involve having to at least insulate the wall. So it triggers a few more things than what we've talked about today.
Okay, is that testimony or an argument?
Hold on. Hold on.
It hasn't been addressed. As far as whether permits were pulled to encompass the, everything involved on the shed cottage.
Is that testimony?
Yes, let me clarify, I think.
Yeah.
Okay.
Let me ask him a couple of clarifying questions. Okay. Based on the evidence you heard today, an air conditioning unit has been installed in the residence.
From the photos I'm looking at, it appears to be, yes.
Under a building code, if a building is converted to from a shed to a garage and is air conditioned, are there additional building codes that have to be met?
Correct.
What are those additional building codes? As you can remember them, I know you don't have the book in front of you.
Well, it would have to meet the Florida Building Code Energy Conservation, which we would have to insulate it. You can't just put an air conditioner in something that doesn't have insulation. And also, to go to a residential unit or a living unit, the shed, I presume, was bare studs when you bought it. Did not have drywall on it, I would presume. So you would have to finish the walls with drywall to meet flame spread and smoke developed ratings for living quarters.
Okay. And would a CO be required to occupy the shed as a living unit?
You would issue a new certificate of occupancy because the record type is change of occupancy.
Okay. No further questions.
Any cross?
Yes, what type of AC unit is this?
It looks like a window unit.
Okay, so it's not a traditional HVAC unit?
It's not a central air conditioning system, but it is, the code defines it as conditioned airspace, regardless of how you do it.
And you said that you're presuming that there was no drywall? You have no evidence of this, do you?
Well, most sheds don't have drywall. If it did, I doubt it would have been insulated as well.
You have nothing to base this on but pure supposition.
Well, I've inspected thousands of sheds.
Did you inspect this?
This one, no.
The
No.
structure?
Yeah,
Okay.
so, but most of the pre-manufactured sheds come out with bare stuff. I rarely see, I don't think I've ever seen one that comes out finished.
Is your understanding that this is a pre-manufactured shed?
No, it isn't. No, it isn't. You're
Then why
correct.
would-
You're correct. I'll stand corrected.
Okay,
Yeah.
so you can't presume that it would just be studs since it's not pre-manufactured?
Well, if it was a shed, storage unit. If it was a shed, most of them are not finished.
Okay.
But that's really not my main point is it should be it should be insulated.
But
If you're gonna condition the airspace,
And you don't know if it's insulated or not?
do not.
Okay.
Yeah.
No further questions.
Is there any redirect?
Does the installation of insulation require a permit?
It would have been it would have been, you would get a permit for that.
Okay.
The main thing you would get a permit for is because you're going from non-conditioned space to conditioned. And those would be items that would have to be addressed to do that.
Thank you.
I would, normally I allow the petitioner to make argument first, and then I turn to the respondent to make argument. Does the petitioner have any closing argument?
Yes, Your Honor, just based on all of the evidence presented both by respondent and petitioner, the evidence clearly shows that the unit to the right of the residential property was built as a shed. It's what it was permitted as in 1997. Many permits have been taken on this property subsequent to the building of the shed in 1997. Clearly illustrating that Ms. Hoagland knows how to get permits, knows what she needs to do to abide by the county code. Unfortunately, her inheriting a converted shed, if her testimony is to be believed on its face, does not wipe her hands clean of still having to abide by the county's code. So at this point in time, she needs to get a new permit to convert this shed to living quarters. The permits that have been drawn down are all items that are not necessarily required to convert this shed to a cottage. Putting a roof on a shed is not something that converts it to a cottage. There's a windows permit. The permit itself doesn't say the windows are for the shed. Ms. Hoagland's testimony is that they are. Some sheds have windows. Just because you put windows in a shed, if that did occur, does not convert it to a cottage. Putting gas around a shed, but mainly in the main house, as the permit shows, does not convert a shed to a cottage. Her testimony and the evidence they presented, including the Generac generator, shows that she knows she's in a floodplain. She knows things have to be elevated in a floodplain. The dismay she presented to the court that her shed might have to be raised up to new county codes to comply with FEMA or any other floodplain requirements was a bit surprising, since her testimony right before that, or right around the same time, was that she's aware that she's in a floodplain because she had to raise her generator approximately 2 feet off the ground. Nothing that Ms. Hoagland has done to this property is, she hasn't put anything into this property that wouldn't have, I'm trying to figure out how to word this. We're not asking her to undo something. It's not like we permitted a shed, we permitted the conversion of all the inside property, we converted all, we approved all the plumbing, and oh my goodness, we're surprised after doing the plumbing and the insulation, and then we're surprised it wants to be a shed. No, everything she's done are things that people could and would do to a normal shed to maintain it as a shed. Those are not things that need to be done to convert it to a cottage. So we're not asking her to undo something that she spent thousands and thousands of dollars on converting it, and then suddenly we act surprised. The county, in its documents, has this as a shed. How she chooses to refer to it on a site plan is not something the county controls. The owner or the builder is the one that creates those documents. The county does not create those documents. So nothing in the county record and nothing in the testimony today has indicated that this should ever have been converted to a shed or living arrangements. She has the option of converting it to a shed legally, applying for a permit, but then she has to abide by all the FEMA regulations. Or she can convert it back to a shed and her son can reside in her residence, which based on her testimony, he already does about 50% of the time. That's an approximation based off her testimony. So at this point, the county believes it's met its burden. In fact, respondents' own evidence shows that a cottage, auxiliary dwelling unit, whatever term you want to use, is required to have a permit. She has to apply for a permit. And we would request that a violation be found and that she be given time to apply and convert this property accordingly, or convert it back so that Mr. Garner can go in and do his inspection to show that it's been converted back to a shed.
Thank you.
Thank you, Your Honor. I would disagree with how I interpreted the county's characterization of Ms. Hoagland knowing how to pull a permit, but just not doing it for this one. I think that the evidence shows that she's taken every reasonable step that any prudent person would take in making sure that everything is done properly. This property was advertised to her as a cottage. The disclosure said that there were no issues with it. Everything that she's relied on showed that there were no issues. Even after she purchased it, she had work done herself where she fully admitted, this is a cottage and this is what I'm doing to it, because it was her presumption that everything was done properly and that this is a cottage. She wasn't trying to hide anything. She put it on the site plan. She put it on her permits, and all those permits were issued to her, inspected, and had no problems. Additionally, I don't think we have any evidence from the county of what exactly has been constructed or modified on this structure that would make it a residence, that would go from a shed to a residence. They've admitted that they don't know what the plans were. I've done a records request to see any kind of site plans or details, and unfortunately, that file appears to have been destroyed. We don't know what Mr. Massey, her predecessor, previous owner of this property, had permitted. It's my understanding, Mr. Massey is not here to testify to it, that everything, the kitchenette, the plumbing, the electricity was there and was approved per the permit in 1997 that he approved. So I would argue that there is no violation of the code here. And if I continue into, if there is a violation, I would like to get to the estoppel argument as well, but I don't know if you want to take up the argument on whether there is a violation first.
I need to hear your estoppel argument.
Okay. So as I provided as Respondent's Exhibit X, what I provided is Castro v. Miami. It's 967 Southern 2nd, 230. The facts there, I believe, to be substantially similar to this one. In that case, Miami-Dade Code Enforcement was attempting to enforce a setback violation. In there, the property or the structure that was alleged to be in violation had been there for over 20 years, and also the new owners, built by a previous owner, and the new owners had pulled subsequent permits for various improvements to the structure that was in question. The holding in this case is that the doctrine of equitable estoppel may be invoked against a governmental entity when, 1, the property owner acted in good faith reliance, 2, upon some act or omission of the government, and 3, has made such substantial change of position or has incurred such extensive obligations and expenses. Sure, my apologies. And I'll go back to 3, has made such a substantial change in position or has incurred such extensive obligations and expenses that it would be highly inequitable and unjust to destroy the right that he or she has acquired. I think that's very applicable here. I think the evidence shows she's acted in good faith, that the county has continually issued permits when she's been very transparent as to this being a cottage, and all the work that she's done, the purchasing of the property, the having her son live there so that he can have a place to live where she can take care of him while also maintaining his independence is something that she's taken on, obligations and expenses that she's taken on that would make this inequitable. And turning to Head Note 6 of the case, the doctrine of equitable estoppel, it's based fundamentally on the rules of fair play. I think in this case we have a structure that's been there for 27 years, that's been properly permitted with no issues, and Ms. Hoagland here has done everything that a reasonable person would have done. And then lastly, as far as the case law, Head Note 8, a citizen is entitled to rely on the assurances or commitments of a zoning authority. If he or she does, the zoning authority is bound by its representations, whether they be in the form of words or deeds. So I think in this case, if a violation is to be found, that the county is equitably stopped from enforcing that against her.
Okay. I'm going to ask one more time if there's anyone from the public who wants to be heard. All right, go ahead.
Can I address the equitable estoppel issue? Or do you want me not to address that?
I mean, I give people a chance to be heard if you have a response.
We actually do, Your Honor. We actually were going to reference Monroe County v. Carter, which is 41 Southern 3rd, 954, where in that case it observed that Castro, the case that he has included here, at the outset of the doctrine may only be applied against a government entity under exceptional circumstances. And in this case, those exceptional circumstances are not met. There was no act or omission by a government, which is the second leg of the equitable estoppel argument that counsel has made today. Additionally, there have not been substantial change in position by the county. The county has always held this out to be a shed. All subsequent permits that came in would have been appropriate for a shed. And there's nothing that Ms. Hoagland has done to this property that we're asking her to undo that would be highly inequitable or unjust or destroy any rights that she has. She can convert a shed to living quarters. She just needs to get a permit. She has to get a CO. Again, in Monroe County, part of what they looked at was that a permit was never received, and a CO for the ground floor apartment was never issued. Sorry, CO is the certificate of occupancy. So in this case, we don't believe equitable estoppel would apply, and that the court needs to provide a standard fine that you would in these circumstances.
All right, I'm ready to issue a ruling. So I think that, first of all, I want to say this has been the most complete, well-argued, well-presented case I've had in my several years as the special master in Citrus County by both sides. I'm really impressed. That won't be much consolation for one side, but here's what I'm going to say. I think what I really struggle with in this case, I'm going to find that there's a violation, and here's why. Section 18-8, subsection A, this is really just the plain language of the code. It says, no person shall erect, construct, enlarge, alter, repair, move, improve, convert, change the use or occupancy of any building or structure subject to this code. And the issue for me, I'm not really going to find a violation based on anything else. I am going to find a violation based on the change of the use and occupancy. I think based on the evidence, it's quite clear that it was originally permitted as a site-built shed without residential character. It is shown that there may have, maybe the property owner wanted it used as a cottage and as a residence. Maybe they used it as a cottage and a residence. I don't find that that was ever ratified by the county in its permits. In other words, they didn't seek the permit under 18-8A that would be needed, and that incidentally would be needed for Castro to apply. Castro is distinguishable because that's a case where something very specifically was permitted decades beforehand, and then the county yanked the rug out from underneath the owners by changing the law, and then they tried to initiate a code case. I mean, frankly, that was probably malicious prosecution and a 1983 action as well. I actually disagree with the county on one thing. I think that the owner has very equitable and moral grounds to continue using the property as it is. It's undisputed under the testimony why the property is needed for the way it's being used. But I don't find that that overrides the plain text of 18-8 subsection A. And I think it has to be read with LDC 3102 sub B. So that's the finding I'm going to make factually and legally. As always, my orders can be appealed. That's it.
Yes, Your Honor. I think we do need to address the remedy, though, in this
Yes.
case.
Yeah, because I have to give a time to abate it, and I don't know exactly what the remedy would be.
And that's, I have a similar thought to you. And I think, the county's requested remedy is either conversion or removal of the cottage. I don't think we've established what actual structural conversions have taken place. I believe what Your Honor just said is it's the actual use and occupancy, but not any kind of structural change that's taken place. So I would think that what we have here is perhaps I would suggest a nominal fine, one-time fine, or, if we're just saying we need to change the use, I think.
The fine's not the issue in my perspective. Because what I'm obligated to do is to give you a reasonable time to bring the property into compliance. That necessarily depends on what the remedy is. So I guess let me turn to the county. How do they abate this? But except for removal. Is there a way to remedy this short of removal?
Through the permitting system.
Right, and so that's hence the testimony about the setbacks and other things. But how long would this take based on your testimony regarding plans and other things? Assume they brought it today.
Right, so depending on what was required with what is there. Just what's there and what is required, I can't speak to that. It should have to do with, of course, the electrical and the plumbing and all this, the upstairs loft, I don't know, the banister, if that was put in correctly, things like that should be inspected.
So you don't really know because you don't know what exactly would need to be changed. But I guess what
At
I'm
this
asking
point,
is,
no.
it's a permit issue, correct?
Correct.
I mean, that's the way I read the code. So what I'm reading in the code is that they need a permit for what they've got or to
convert
remove
this
it.
To a, right.
Correct, yeah.
Okay,
If I may.
yeah,
Because, as we've said, this seems to be a use issue, would a proper remedy just be to cease using it as living quarters? And then can we clarify what that means? I mean, if it's similar to a, for lack of a better term, man cave, are you allowed to hang out in it during the day? Is it just the sleeping that we have issue? We've established that he doesn't cook or do his laundry within this structure. So would is it you can't sleep in it? And does that take it out of the character of a dwelling?
At this point, to be with code, as our building official testified, it can't be insulated. It can't have, if there's upstairs, the banister, I don't know that that's to code. So if it's going to still be used as something other than a shed, you put your shovels in it, you put your wheelbarrow in it, then it needs to, they need to allow our county officials to come on the property to see that it's been converted back to a shed. If they want to be able to live in it during the day as a man cave and they want the luxury of air conditioning and electrical and plumbing and all the other things, then that's an occupancy.
I've
and they
seen
would
air
need to be a
conditioned
shed.
sheds. So I think you're both onto something, and that I'm gonna have to make findings as to this.
But were those sheds legal
Yeah.
Okay.
I mean,
in Citrus County?
I do not know. I do not know. Yeah. Is the county required to base this case on a complaint?
The complaint was from the floodplain manager,
Oh, really?
correct? Based on the fact that it was being used as a residence.
I'm sorry, based on the fact that.
It was being used as a residence.
Well, Mr. Hartley, you've raised I guess, an important point, because I don't want to set someone up for failure, so I need to make some findings. I do find that if it's no longer used residentially, that will abate the violation. But it is the issue that I'm finding a violation that it was changed. So what needs to change back? I'm going to have to rule that the changes that were done in order to make it residential or habitable would need to be undone. The changes on the record, well, let's discuss that. Some of the things that have been discussed could be done on a non-residential shed, theoretically, but I agree, you don't customarily see it. I don't think that an AC unit a window AC unit necessarily is residential. I don't,
What would define it as residential would be if you had sleeping quarters, that's by definition.
yeah, that's where I'm headed. Yeah,
Yeah.
I'm not concerned with the AC. I think it's a darn good
Well-
idea if you can have a window unit in a hot shed.
Well, actually, to receive a CO as a residence, it would have to have, believe it or not, in Florida, you gotta at least have heat.
Really?
Yeah. You have to have heat.
Well, so it's the sleeping quarters, it's that kind of stuff that I'm concerned with.
That's what defines it as a residential unit. Any portion of a building that's used for sleeping. And-
Okay, then that's what I'm going to find, that if those kinds of things are undone, past inspection, that the residential character will be undone. Does that make sense?
It makes sense, but my interpretation of that is you remove a bed. Is that a fair characterization of if you're removing?
It'll be one, I mean, that's one thing for sure. I don't know if there are other things, but that is gonna be subject to the inspection.
What typically, the hallmark for a bedroom to me is if you have a closet with a hanger.
A closet with a handle?
A hanger.
Hanger.
Oh, hangers.
Mhm.
I think
That
look, if in your interpretation this isn't hard to deal with, then you might not want to telegraph everything at the hearing. I mean, but what I'm saying is, I'm just saying that the residential character, based on the testimony of Mr. Acosta, that's what has to be undone as one of the ways that this can be abated. Yes. Okay? I'll issue a written order, though.
Thank you.
All right, thank you.
Christian?
Yeah.
We're not gonna give them a period.
Oh, I'm
of
sorry,
time.
I have to give you a period of time. How much time do you think it would take for you to do one of these things? How much time do you want?
So it's to remove the bed, that's it, right?
30 days?
Just to remove the bed.
I'm gonna give you 60 days. If it's, what's the county's recommendation as to a fine if it's not brought into compliance in 60 days?
Citrus County License Compliance Division respectfully requests the special master assess a fine of $100 a day along with administrative cost to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owners, and they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask special master additionally find the respondent's responsibility to contact the License Compliance Division when the violation has been abated in order to.
Okay, I'm gonna give you more time because y'all have made a very sufficient showing that you've attempted to comply with the code. You've already remedied other stuff. I'll give you 60 days to comply. If it's not brought into compliance as ordered, $100 a day.
Thank
Okay?
you, Your Honor.
Good luck.
And Your Honor, they also have the option of just converting it to a dwelling unit, actual residential living space
Yeah,
as
that's
well.
why if they had
Okay.
wanted to do that, I would have given more time, but that's okay. All right, thanks.
Next case on the agenda, Thunderbird MHC LLC, case number 2024-00545, Code Officer Cody McGuire, page 28 of your agenda. One sec.
What page on the agenda?
28.
28.
Cody, did I swear you in already?
Yes, ma'am.
I did. So it's just you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Can you please state your name?
Nicole Rodriguez.
And ma'am, can you state your name, please?
Attorney Grace DeMio for the respondents.
I'm sorry, what is your name, ma'am?
Let me move this up. Attorney Grace DeMio for the respondents.
Okay, thank you. And how do I spell your last name?
D-I-M as in Mary, E-O.
D-I-M-E-O? DeMio?
Yes.
Okay, thank you. Go ahead.
All right. Citrus County, or Cody McGuire, Citrus County Code Compliance Officer, case number 202400545, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 4401 North Suncoast Boulevard, Crystal River, Florida. Property owner is Mobile Home Park LLC. Goods service via signed certified mail return receipt and posting at the Canto Government Building. I would like to authenticate the following documents and be admitted and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on March 25th, 2024. Corrective action inspection on April 8th, 2024. And photos of my final inspection conducted on May 14th, 2024. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a copy of the signed certified mail receipt, and then a pre-hearing order. And Exhibit C is environmental health sanitary nuisance form.
A what? Environmental health?
Sanitary nuisance form.
All right. Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing. Take your time.
So that was in March. Looks worse than what it is now. This one is, this is our standard packet that we already got. Was this the one you were telling me about? The health department one. Okay. Interesting. Yeah. Well, I want this in, so I'm not gonna object to that. Okay. No objection.
Okay, thank you. And while they're reviewing, may I ask, is there anyone from the public who wants to be heard on this case? All right, I don't see anybody. Thank you. And Ms. DeMio, are y'all contesting that a violation exists?
We don't contest that a violation exists. We're contesting that the wrong person has been cited.
Okay, all right, go ahead.
Okay.
And Exhibits A, B, and C are admitted. All right.
Okay. On March 25th, 2024, I conducted an initial inspection and observed the property to be in violation. A notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On April 8th, 2024, I conducted a corrective action inspection and observed that the property remained in violation. I've had contact with these two ladies over here throughout, and on my final inspection on May 14th, the property remains in violation.
And what was the nature of your contact with, quote, these two ladies?
I first received a call from Rodriguez saying that they were in the process of evicting lot number 42, and that her belongings were going with her. And then shortly after that, I had received a call from Ms. DeMio.
Okay. All right, so what would y'all like to say? And are you all representatives of Thunderbird MHC LLC?
I'm the attorney for Thunderbird Mobile
Okay.
Home Community, and she is the community manager, so she's an agent, and she'll
Got it.
also testify.
Okay.
To start off, we're contesting that this is a statutory issue, and under Florida Statute 723.023, the wrong person has been cited here.
723 point.
023, yes, sir. Is it your honor or sir? I haven't
You know,
been-
it's whatever you choose. I've been called a lot of things here.
Okay.
It's 723 point.
023. I have a copy
023.
as our exhibit
Yeah.
E if you'd like a copy.
And incidentally, do you have any cross-examination?
I do.
You do? All right,
I
okay.
start with
I-
preliminary explanation and then.
Your preliminary explanation would be helpful, yeah.
May I push?
Yeah, of course. Thank you.
Your Honor, this is a special case where this is a mobile home park, and so we're governed under 723, the whole broad spectrum of Florida Statute 723. And under 723, the only person who can be violated for a code violation such as this is the actual owner of the mobile home. The community only owns the actual land, and the statute specifically says that the mobile home owner has to pay the fine and is in charge of it.
If you would, let me read this statute
Yes, Your
very
Honor.
quickly. I understand your argument, and I'm familiar with these areas, so let me just check this statute.
And I
out.
have one more statute as well that's, if you would like, that says that 723 preempts everything.
Yeah, I would
Any-
like to see that.
So, may I approach?
Yeah, of course.
This is 723.004, and it says that the entire Florida Statute 723 preempts any local code violation, any local ordinance.
Okay, takes me a little bit of time to read this, so let me just absorb it. Do you have any case law on this?
I do not, Your
No, and
I
it's
don't, I've
fine.
looked.
I guess
but-
I'm curious, the way I read this, before we get into, you're absolutely free to do that. A mobile home owner shall, and it says the homeowner is responsible for all fines imposed by the local government for non-compliance with any local codes. And I guess when I do see the preceding sentence where it says at all times comply with all obligations imposed on mobile home owners
Yes.
by all applicable provisions, including compliance with building permits, construction requirements for construction on the mobile home and lot. Where what I'm looking for is the gap that says that the homeowner is responsible for all fines imposed by the local government for the lot.
If you look at the next one.
Yep.
Number 2, at all times keep the mobile home lot that he or she occupies clean, neat, and sanitary, which is exactly what this case is.
I mean, I think that means they have an obligation to do that.
Correct, and if any of the violations are, if they get any violations, the preceding sentence, I would argue, says that the violation should go to them, because I'll get to this argument later.
All right, then I'll let you,
Okay.
I understand where you're coming from, and I'll permit you cross-exam.
Okay, thank you.
Can I respond to the legal argument?
Yeah.
There's other provisions in the chapter 723 that apply here.
Well, then I guess, and I'm not trying to, the reason why is because I haven't really made up my mind yet.
Oh, okay.
I think I'm going to have to permit argument after the cross-exam,
All right.
if you don't mind.
Okay, what's your last name again, Cody?
McGuire.
McGuire. Mr. McGuire, what's the statute that my client has been cited with? What local code number?
It's accumulation of junk and debris, Chapter 20, Article 3, Section 20-31A.
Is this the citation that they've been charged with, 20-31A?
It is unlawful for the owner or occupant.
Can you read the first sentence of 20-31A, the citation that they've been charged with?
It is unlawful for the owner or occupant of any land to permit, cause, or have thereon any accumulation of junk, rubbish, or vegetative matter, except.
Sure.
I have the statute for you, and it's just the first sentence that I can cut out. Going back to that first sentence, it says, "It is unlawful for the owner or occupant," is that correct?
Correct.
Who has been cited in this case?
The mobile home park.
Are they the occupant of the mobile home?
I'm not sure.
Have you tried to find out who lives in the mobile home?
Yes, ma'am, but they didn't say whether or not they, I don't know what I'm looking for, are an owner of the mobile home park.
So who did you cite in this case?
Thunderbird MHC LLC.
Did you cite the individual owner who lives in that mobile home?
No, ma'am, we go after the property owner. That's listed on the property appraiser's website.
Thank you, but the first sentence of 20-31 says owner or occupant, correct?
The owner that I cited would be Thunderbird Mobile Home LLC.
Yes, but according to 20-31A, you could have cited the owner or occupant, correct?
Correct, but I'm
And-
bound by statute to go off of the property appraiser's website. And they listed at that address of 4401 North Suncoast Boulevard, Crystal River as Thunderbird Mobile Home LLC.
So you didn't cite the occupant in accordance with 20-31A, which is what the citation is based off of?
No, ma'am, I went after the property owner based off of the property appraiser's website.
You said you've had conversations with Ms. Rodriguez here. What have those been in nature?
Ms. Rodriguez had claimed that they had filed an eviction notice and that they were in the process of getting her moved out.
Looking at the pictures. These were, do you recognize these pictures?
Yes, ma'am, I do.
Would you say the accumulation of items in this lot are close to the home?
It's still not in a four-walled or roof structure.
Yes, but looking at the pictures, if you're looking, I'm going to introduce this a little bit later with my own witness. But here's just a copy for you now. Thank you.
Thank you.
Looking at these pictures, especially the first one right there, is there a bunch of items just strewn all over the front of the lot, or are all the items more condensed right next to the mobile home? Flipping through the pictures.
It's a mixture of both, but the majority of the items are under the carport.
How would you expect the community to deal with all of these items if they don't own them? Since you cited them, and they don't own the belongings.
The mobile home.
Well, I'm asking how he would like us to comply if we don't own the belongings.
I'm gonna allow it.
How would I expect?
How do you expect them to comply or abate the violation?
With a legal amount of time to abate the situation, to allow me for reinspection.
If they're not the owners of those property, of the belongings that are next to the mobile home, how would you expect them to clean them up?
I would expect the mobile home.
Hold on, before you let your attorney
It
make
calls
the.
for a legal conclusion that I don't believe he's qualified to make at this point as well.
I disagree. I think that she's asking a practical question, and normally, I mean, we've dealt with this in other cases, so does the question make sense to you?
Well,
How would I
believe-
expect the mobile home park to clean it
I
up?
believe she,
If they're not the
in her
owners, yes.
question, she stated they have no right to.
I didn't.
She didn't say that,
Okay.
yeah. That's what she's implying, but, but go ahead, if,
My expectations would be for anybody else who would have a violation in front of them.
okay.
How come you haven't cited the owner of the property, of the actual physical belongings that you want removed?
Because I went after the property owner, which is Thunderbird Mobile Home LLC.
But you technically can, according to 20-31A, go after the occupant because it specifically says occupant in the first sentence.
Is there a question?
Yes, you can, because it does say occupant in the first sentence.
Yeah, but then it also says the word or.
Correct.
And my or was the findings on the property appraiser's website.
And you chose to make a decision to go after the owner of the actual physical land.
I didn't choose, that's my job.
No further questions at this time.
Okay. Do you have any other witnesses?
I have witnesses for my own draft,
Yes.
Your Honor.
And, yeah, do you have a read? Do you?
I would like to ask him some questions. We also have the health department here.
Okay,
Part of
yeah,
this case as
absolutely,
well.
yeah.
Thank you. So we're not done with our evidence.
Okay,
yet at this
gotcha.
point. Mr. McGuire, to your knowledge, is the mobile home park the owner of the lot?
Yes, ma'am.
Who made the complaint?
It was a sanitary nuisance complaint from environmental.
Can you repeat that? I didn't hear that last sentence.
Sanitary
I'm
nuisance.
sorry, you can ask me, but it's the county's time to ask the
I'm sorry.
question. I'm just
Yes,
trying
Your
to
Honor.
keep some order.
Can you, Your Honor, can you ask him to repeat that last sentence? I didn't catch it.
You can do that on your recross, but
And in this case, did the property appraiser's website indicate Thunderbird MHC LLC and an address?
Yes, ma'am. 520 North Main Street, Royal Oak, Miami, 48068.
And is that who you notified of the violation?
I notified them and the registered agent.
And they contacted you after you sent the notice?
I received contact from Nicole Rodriguez after I received the notice, or was sent the notice. It's also listed as 14.11 acres.
And how much time did you give them to clean up the property?
I believe it was 2 weeks, but without seeing it in front of me.
And was it cleaned up?
No, ma'am.
What was the date of the notice of violation?
On March 25th.
Are you recommending a fine at this point?
Yes, ma'am.
What would the fine be?
It would be $75 a day.
When you went to the property, was there a noticeable odor emanating from the property?
There was a very pungent smell when I hung my door hanger on the swinging door of the front porch.
I have no further questions for Mr. McGuire, but I would like to call Courtney Carmichael as a witness.
well, before that, is there a recross?
Yes, recross. Can you repeat who notified you of this violation?
Environmental health.
Was that on Exhibit C of your documents, the health department?
Yes.
Okay. Going back to Exhibit C, I don't have a copy. May I have looking? Can one of you attorneys please provide me
You
a
want
copy?
to look at this copy?
Yes, I do. Exhibit C. Looking at Exhibit C, for
Jumping to the State of Florida Department of Health, who does it say the violation is to?
I don't have it in front of me. It says to Thunderbird MHC LLC owner / occupant,
Does it
or
say
owner
anything?
/ resident.
Or do you know if this was posted on the door to the mobile home?
I believe there's a photo in Exhibit C with something posted from environmental with either green or blue tape on the side of the mobile.
Yeah. So this violation was given to the resident / owner of the mobile home as well as the community, since it says that.
I can only presume owner / resident.
Okay. How come, unlike the code department, which has owner / resident, you didn't include the owner / resident in your violation notice?
Because the owner is Thunderbird Mobile Home LLC.
What about the resident who occupies the home, who actually has control of the junk on the lot? Thank you.
Now may I call Ms. Courtney Carmichael?
Are you done with your recross?
Yes, sir.
Okay, yeah.
Is Ms. Courtney Carmichael?
Yeah, she's coming.
Okay.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. State your name for the record.
Courtney Carmichael.
Could you state how you're employed, please?
I am employed with the Florida Department of Health with Environmental in Citrus County.
Have you investigated a complaint regarding a Thunderbird mobile home park? A
Yes, ma'am.
sanitation issue?
Yes, ma'am.
And what was the problem?
The original complaint came in about 3 parts. It was about the quality of the water there, some rats that they were having issues, rodents that they were having issue with, and foul odor coming from a lot number 42.
And is lot number 42 the lot we're here on today, to your knowledge?
Yes.
The rats were coming from lot 42
Yes.
and going around the mobile home
Brown-
properties?
Yes, it was, the complainant, which is anonymous, stated that it was getting into their shed and destroying products.
Did you go out to the property?
Yes, ma'am.
And could you tell us what you observed?
The first inspector that was out there, did notice odor, large amount of garbage, and did send citation, our sanitary nuisance, to the mobile home park.
And why would you send that to the mobile home park?
Because they are responsible for all the tenants inside of the park, and they are a permitted facility with our health department, that they will maintain a rodent-free and garbage-free area.
Is that required by the Florida Administrative Code?
Correct.
Is it section 64E-15.007, garbage and refuse disposal?
Correct?
And 64E-15.008, insect and rodent control?
Correct.
And you found them to be in violation of that?
Yes.
The mobile home park?
Yes.
Did you send a notice to anybody else?
He sent his directly to Thunderbird Mobile Home Park on, let me try to read his letter here, February 20th, 24.
And did the mobile home park comply with getting rid of the problem?
No, it's still in unsatisfactory status.
Did you yourself send notices to anybody else?
I did. I went out again on March 5th. I put the tenant's information on there as well because it was becoming more of an issue. But I also put Thunderbird Mobile Home on there as well and sent them the notice via email, which I did get response that they received it.
stated that they have a license to operate as a mobile home park?
Correct?
And does that require certain types of reports to be kept for the state?
It does.
Looking at a document called State of Florida Department of Health, County Health Department, Mobile Home Lodging, Recreation Vehicle Park, et cetera, it has an unsatisfactory result. And there's boxes marked off storage and harborage. Could you tell us what the violations storage and harborage mean?
For violation of storage, for number 18, he posted, observed large amounts of clutter stored outside of the mobile home. Lot 42, odors observed, could not identify source, remove garbage, code reference storage 64E-16007, solid waste is processed in manner that does not create nuisance odors, harborage, insect breeding, accident hazards, or air pollution. Garbage is stored in impervious containers with tight fitting lids. Violation number 20 for harborage, he cited observed debris, clutter, overgrown plant matter on lot 42, which is harboring rodents, removed potential rodent harborage, code reference harborage 64E-15008. These premises are to be free from rat and rodent harborage.
Did you perform an inspection on or around April 5th of the property?
Bless you.
Yes, I did.
And as a result of that, did you issue another notice to abate the sanitary nuisance?
Correct.
And who was that notice issued to?
I sent it to the mobile home park via email.
And have they remedied the situation since that time?
Under my understandings, they're trying to evict the tenant, but the cleanup has not proceeded.
So the sanitary nuisance continues?
Yes, ma'am.
I have no further questions for Ms. Carmichael.
Any cross?
Yes, Your Honor. Why did you include on one of your notices the resident owner of the mobile home, in addition to the mobile home park?
Because I was trying to get maximum effort to get it cleaned up.
I'm going to show you pictures, which I will enter later. You can take a look at these.
Are these pictures that you've already provided to me?
Yes, I'm going to
Okay.
enter them into
Okay.
A similar question to what I asked Mr. McGuire earlier. Is there an accumulation of items in the front of the home, or spaced out in front of over the lot?
There is.
Where on this front picture?
This here is not up against the home, nor is the shrubbery and piles of debris that allow harborage of rodents.
What about the accumulation on the very first picture of boxes, cups, that sort of thing? Is there any in the front of the home? This whole front area right here.
If that was a better picture, more clear, I would give you a better answer.
Can you show me?
Is that
anywhere
from
in
the
front?
road to the house, or just halfway through the yard?
No,
is that the
no,
start?
this is just examination, yeah.
Is there any boxes in the front of this home right here from this picture?
From that picture, no.
Okay. In your opinion, are most of these items closer to the house than spread out throughout the rest of the lot?
Well, it depends on the measurement that you're giving me.
Are most of them under the carport of the home?
Most of it, yes.
Okay. When you were doing your violations, who did you think owned all of these items on this lot?
I don't go by that. It goes off of who owns the mobile home park and what your guys,
Sure,
the
but
rules and statutes say.
did you think that all these items underneath the carport were owned by the mobile homeowners who own the land, or the person who owns the mobile home who they're all pressed up against the carport for?
It would be the owner of the items.
Of the
which-
items.
Because I don't know who owns those items, I cannot say that.
Thank you. Similar question to what I asked Mr. McGuire. How would you expect someone who doesn't own the items to remove them from the property?
because you guys have a lease or contract that says your tenants will uphold the rules and regulations of mobile home parks, Florida laws.
How would you expect them to remove them if they don't legally own the items without tossing them in the dumpster and getting sued later?
Depends on what your contract says that you had your tenants sign.
And you are aware that we're actively pursuing eviction against? Thank you.
That's why no fines have been assessed from the health department.
Thank you. No further questions.
All right. Do you have a redirect?
I think I have a rebuttal.
Okay.
I'm gonna have to
We're not
recall-
quite at argument, but
I'm gonna have to recall Mr. McGuire, our code enforcement officer, Cody.
Right, it was Mr. McGuire.
Mr. McGuire. Mr. McGuire, with regard to this eviction, were you provided any information that they're not, as to how they were going to evict the person? On what basis?
I don't recall.
Were you told anything about payment of rent?
I was told over the phone that an automatic withdrawal had been withdrawn from said person's account, and it was
Objection to
extended
hearsay,
to
Your Honor.
one
hearsay
other
is
month.
allowed in a quasi-judicial proceeding. Go ahead.
Continue.
Restating. So I was told over the phone that the payment for rent was automatically withdrawn, and therefore their eviction process was withheld another month.
And who told you that?
I don't recall.
Was it somebody from the mobile home park?
It was somebody representing the mobile home park.
Thank you.
Is that it?
Yes.
Okay. Any recross?
No, Your Honor.
Okay. All right. Do you have any other witnesses?
No, Your Honor.
Okay. I welcome the presentation of your case.
Thank you. Actually, this will be the, may I approach?
Yeah. Okay.
Okay.
May I proceed?
Yes, of course.
Okay. Respondents would like to call Nicole Rodriguez.
Okay.
Ms. Rodriguez, what do you do for work?
I'm a community manager. I manage Thunderbird Mobile Home Park
How long have you been the community manager for?
since March 11th.
Of this year?
Yes.
And what did you do prior to this?
I was a community manager for another mobile home park down in Riverview.
What are some of your duties as a mobile home park community manager?
Uphold all of the rules and regulations of the mobile home park, collect rent payment, walk through the communities, make sure that the common areas are upkept.
Are you aware of the ongoing violations with 4401 North Suncoast Boulevard, Lot 42, also known as Peggy Schuler's Lot?
Yes.
Okay. What's going on with that one? Can you just, in brief?
Basically, this property has been with issues prior to my arrival to the community. Upon my arrival to the community, we had already sent off a second notice of violation, asking her to go ahead and pick up all of the items, at which point the health department got involved. Like Cody said, I did speak to Cody. Cody went out. Upon receival of his notice, I tried reaching out to him. We ended up playing phone tag for a little bit. I ended up getting in contact with Cody. He said that he had spoken to the tenant as well. Me and him kind of missed each other in going to the tenant's house and trying to speak to her in regard to picking up her items. I told him on that phone call how the tenant herself was trying to tell me how all of the items outside of her home were in fact not any garbage, and that they were all her belongings, and that they would be being moved into a shed of sorts, off-site, a storage shed.
Thank you. Are you aware under the mobile home statutes if you can just automatically send her an eviction notice and say you're gone, you have to get out? Is that something that the park has control over?
No, I cannot.
Do you have to send out multiple notices first in order to establish that there is a violation of the rules prior to terminating someone's tenancy in a mobile home type lot.
Correct, it is a process.
Okay. Are you the records custodian for Thunderbird Mobile Home Park?
Yes.
Do you maintain and keep records that are like these rule violation notices in your daily work?
Correct.
Okay. Do you recognize the Respondent's Exhibit A, Notice of Violation of Community Rules issued on February 12th, 2024?
Yes.
Can you please read all of the, first of all, what's the date on this?
February 12th, 2024.
Okay. And is this a document that's kept in your standard records capacity as records custodian? We'd like to admit this into evidence as Respondent's Exhibit 1.
Yes, or is there any objection?
No.
Okay, it's admitted. We'll
Thank
call it Respondent's Exhibit 1, and we'll number them.
Can I actually change it to A? I realized I put A
Yeah, you can
before.
have, I mean, it's pre-marked as A, B, C,
Yes.
and D, I guess, so
We'll stick-
correction, we'll call it Respondent's Exhibit A.
Thank you. The date on this you said was February 12th, 2024?
Correct.
And this was the first notice of violation that was sent out to Ms. Schuler?
Correct.
And this was sent out by Thunderbird?
Correct.
Okay. What are all of the issues that we say are wrong with the lot?
The exterior of your home is dirty and has mildew in spots. You are missing lot numbers on the front of your home. Your roof is dirty and covered in branches, leaves, debris, etc. Your lawn is not maintained and there are leaves everywhere. You have miscellaneous items and junk strewn about your lot that must be removed / stored, wheelbarrow, boxes, trash, garbage, etc.
And what was the cure date? That was,
February 27th of 2024.
was this to comply with Florida Statute 723.061, which allows 7 days and 5 days to
Yes.
comply? And what, did you ask her to clean up everything within this compliance date?
Correct.
And skipping ahead in the notice, there are pictures. Were these pictures taken at about the time that this notice was sent out of what the lot looked like?
I believe so.
On the back of the lot. Okay, thank you. Did Ms. Schuler comply with this notice and fix up her lot by the February date?
She did not.
Okay, what did the community do next?
Send out another notice of violation.
Thank you. Is this it, the second and final notice of violation of community
Yes.
rules dated March 12, 2024?
Correct.
Respondents would like to now admit into evidence what has been pre-marked as Respondent's Exhibit B, as Respondent's B.
County's position. All right, it's admitted as a Respondent's B.
Flipping ahead, are there the exact same violations that I just mentioned from the first one that are still prevalent on this lot?
Yes.
And when is the compliant date?
March 26th of 2024.
And was this to get the home into compliance, fix the code violations, and remove all of the trash, junk, debris everywhere that was stored on the lot?
Correct.
Okay. Was the lot cleaned up by the end of that end of March deadline?
No, it was not.
All right. At that point, did you decide that it was time to terminate the tenancy in compliance with the Florida statutes under 723?
Yes.
And this is a amended termination of tenancy notice dated April 30th, 2024. Was this sent out to her?
Yes.
We would like to enter into evidence what has been pre-marked as the Respondent's Exhibit C as Exhibit C.
County's position.
No objection.
It's admitted.
What did this notice effectively do on April 30th, 2024?
This one stated that she is going to be evicted. She has 30 days to vacate the premises.
And when is the vacate date?
June 6, 2024.
Is that within 30 days and 5 days mailing of sending out the notice, which was April 30th, which is compliant with Florida Statute 723.061, giving them 30 days to vacate?
Correct.
Okay. If you could have gotten her out earlier at this point, would you have?
Yes.
How come you haven't removed the junk off of the lot yourself? Does the community or you as Nicole Rodriguez own any of these boxes, items, cups, mugs, towels, personal belongings that are all stored under the lot?
No.
Okay.
And as previously stated, she said that none of it was garbage. When I did approach her about it, she said none of that was garbage. It was all personal items.
Have you taken, I'm now looking at Exhibit D, which you already have. When did you take these pictures?
Yesterday.
Yes. I'm sorry.
Did you say this month?
Yesterday.
Yesterday.
Oh, yesterday, okay.
Are these pictures a fair and accurate depiction of what the lot currently looks like right now?
Yes.
Okay. Respondents would like to enter into evidence what has been pre-marked as Respondent's Exhibit D as Exhibit D.
County's position.
No objection.
All right, they're admitted.
I want to talk specifically about what items we're seeing here since, well, let's just talk specifically what you're seeing in here. Tell me what you see, specifically point out the items.
Boxes, a humidifier, a jug of liquid, cat litter, chairs,
Equipment.
yeah, outside equipment, trash cans.
Could some of these items hold some minimal value?
Yes.
Were there any items really in the front of the home? Let's look at this picture.
Not many.
Okay.
She had them all tucked away.
Can you repeat
There
that?
was not many items. There was just one item that was away from the home itself a little bit, which was a wagon, I believe. Other than that, all of the items were close to her home.
And the community doesn't own any of these items?
Correct.
All of these items, are they all on a lot that the resident, Ms. Schuler, leases from you, the community?
Yes.
If these items were on community property, which is not leased out, would you have removed them by now?
Yes.
Is it your intent, as soon as this eviction is over, to remove all of these items and get the home into compliance as soon as possible?
Correct.
Is there anything that you physically can do lawfully, in your opinion, right now to remove these items?
No.
Okay. That's it for me, Your Honor.
If I can quickly state, I also was told by my regional manager to not go onto that lot within her home because she had threatened the previous manager with her gun. So,
Okay.
Good to know, thank you.
Is there any cross?
No.
All right. Do you have any other witnesses?
No other witnesses, Your Honor. I just have arguments on why they shouldn't be the one being charged with this.
All right. Well, then I'd love to hear from the county on its case closing first, and then we'll hear from respondent. And I've pulled up Chapter 723 on my phone.
I have copies for
Okay.
the pertinent portions that we're talking about.
Thank you.
First, I'd like to point out that the preemption language in 723.004 states that all local statutes and ordinances in conflict herewith are expressly repealed. However, it does not state that Chapter 162 does not apply to these types of
I
proceedings.
don't find that there's anything in 162 that's been repealed.
And under 723.022, a mobile home park owner's general obligations are outlined. The first of which is to comply with the requirements of applicable building, housing, and health codes. This case comes out of a violation of a health code and the existence of a sanitary nuisance. That's what was found on this property, and that also means that they're responsible for it, the mobile home park itself. Under section 723.025, the mobile home park owner has the right to enter onto a lot for purposes of repair and replacement and protection of the mobile home park at all reasonable times. So the mobile home park has always had, under this statute, the ability to go on that property and clean it up to stop the sanitary nuisance from existing any longer, and they did not. That's why the mobile home park has been cited, in addition to the testimony that was given by the code officer, that he sent the notice to the mobile home park because that's who's listed on the property appraiser's website as the owner of the property, and that's who's provided notices of violations. I've also got copies of, I believe you've been given them, the Florida Administrative Code provisions regarding garbage and refuse disposal and insect and rodent control. Yeah, it was all, it should all have been together. Was it together?
I have it.
Okay.
Yeah.
Under 162, the county is permitted to bring before the special master cases concerning violations of any codes. And we have, the basis for the notice of violation is the nuisance itself, which is the junk and debris, and the junk and debris is what caused the sanitary issues, having rats come off the property onto other tenants of the mobile home park's property. And the whole concept of Chapter 162 and the county's codes is to protect the health, safety, and welfare of the citizens of the county. That's also the basis for the health department's codes. And so they all work together, and the ultimate person responsible under Chapter 162 is the owner. And the owner, in this case, even under Chapter 723, had the ability to go on the property and clean it up. So they were properly noticed with the violation and properly held accountable for the violation.
Thank you.
Is this final closing?
It is, if you wish to give me one.
Yes, yes, Your Honor. We would argue that, first of all, under 162.09, it says that the may order the violator to pay a fine, and then it goes into all of the violators' responsibilities and duties. We would argue that the community is not the violator, as you've heard today. As you heard from code enforcement and from the health department, they don't even have a solution in this case for how my client could fix the problem of somebody else's debris on this home. It wouldn't be fair or ethical or equitable to have them be the one to have to pay this fine. And they shouldn't have to pay the fine under 723.023, which specifically states that all fines for the home of the lot have to go to the actual mobile home owner. You heard from code enforcement today that it was the boxes and junk which caused the violation notice to be sent out. And that's why we're here today. It's not because of the sanitation issue. It's because of specifically code enforcement saying that there was all of this trash piled up. Well, you also heard from Ms. Rodriguez that the owner of the home and the resident of the home says this isn't trash, this is her personal belongings. This would be a huge problem if we got rid of her personal belongings, which she is claiming is her actual belongings and not trash. The community was unable and is unable to remove these items, and they're trying everything within their power under 723 to get her out as quickly as possible. So we would ask that you dismiss the fine and the violation against the community, and instead we would ask that code enforcement find the actual person responsible for all the junk, the owner of the home and the resident, who's the person who actually accumulated the items.
Is there anyone from the public who wants to be heard again? All right. As a first matter, I do think that typically violators under Chapter 162, as well as the Citrus County Code, can include the owners because there is something they can do, which is evict the person, and y'all are doing that. But when I read the code, and I'd like to hear from the county on this, I think I agree with their argument, and here's why. If I look at Florida statute, 723.024, subsection 2, it says, a lien, penalty, fine, or other administrative or civil proceeding may not be brought against, and then first it talks about things that can't be brought against the mobile homeowner. You can't hold the mobile homeowner responsible for things that are the park owner's responsibility. But then it says, or against a mobile home park owner or mobile home park property for any duty or responsibility of the mobile home owner under 723.023. And then subsection 2, it does give, it says, at all times keep the mobile home lot that he or she occupies clean, neat, and sanitary, and maintained in compliance with all local codes. That's directly, squarely on point with this case.
Well, it uses the word may, which is permissive, not mandatory.
And where's the may? Let me see. Oh, may not in .024 sub 2.
Yes.
Okay.
Which is what you're referencing. And the fact that there's a violation on this property, Ms. Schuler may have been the person who created the violation. However, the mobile home park, by not going in and remedying it, which they had the right to do so, allowed the violation to continue and maintain the violation.
I agree with that.
Now, and then if under 723.024 subsection 1, it says if a unit of the local government finds a violation of a local code or ordinance has occurred, the unit of local government shall cite the responsible party for the violation. Since the mobile home park has an obligation under 723.022 to comply with the requirements of the health codes, they are the responsible party. If you are stating that subsection 2 of 723.024 prohibits the county from bringing an administrative action before the special master, then that means that Chapter 723 violates the separation of powers by limiting a county attorney, which is considered as an executive position with a local government, limiting their ability to determine who and how they want to proceed with a code violation. It would mean that we can't bring code violations before the special master, which Chapter 162 allows us to do.
I don't think it does that. I think what it does is it's basically saying that as a matter of state law, it's going to explain what the responsibility is. So under 723.023 and reading it together with 723.024 sub 2, it says that the mobile home lot that he or she occupies, keeping it clean, neat, and sanitary, that's a responsibility of the mobile homeowner. And under sub 2, it says that a proceeding can't be brought against the mobile home park owner for that specific responsibility. So it's, what it does is it's not a separation of powers, it's preempting.
I hate to say,
And
you
that
just said that the lot owner is responsible for keeping things sanitary. Well, so is the mobile home park owner.
Where?
Section 1 of 723.022. They have to comply with health codes. And the health department determined this was a sanitary violation
I
and a
agree.
violation of the sanitation.
And they're doing that, and they have that right. It's not cited in your notice of violation at all. The only thing cited in the notice of violation is 20-31A.
Except it says to clean, the abatement is to clean it up.
It's not in the health code, it's in your local code. So I
And
agree.
we have the ability to,
But you didn't.
when the health department is unable to cure a problem, they can turn it to code, and then code steps into their shoes basically to enforce the requirements of the law.
And then your notice of violation says 386.041 sub 1, the way that their notice does.
And underneath, though, it says more for the
Yeah,
abating,
it
to clean
does.
it up.
Yeah.
Because under our code, let me get to the nuisance provisions, because this is under the nuisance provision. The purpose of chapter 20. A nuisance condition, in the definition section of chapter 20.
Yep.
20-3, nuisance condition shall mean an unsanitary, unsafe, or grossly unaesthetic condition that presents a threat to the health, safety, and or welfare of the public. The violation was for a nuisance, and a nuisance is an unsanitary, unsafe condition. So, under our own definition, this is unsanitary, which is a health code type violation. It puts at risk the health of the public.
It's a health code type, but it's not a health code. And under your interpretation, it would read, I think it would render 723.024 subsection 2 it would render it ineffective. It would give you the discretion to determine which of these responsibilities are the mobile homeowners or the park owners. That's not what this statute does.
Well, it's the ultimate responsibility of the mobile home park to keep things sanitary and keep their residents safe, which is why they're allowed to go on to a rented lot to clean it up. So they've had the ability to do that this whole time.
I think their
And they're
lobbyists.
trying to state they don't have that duty, but they do.
I agree, but not under this code. Not under 20-31A pursuant to 723.023 read with 723.024. I think their lobbyists bought a pretty good law that insulates them from having to clean up after, because this probably happens a lot in mobile home parks, and so I just don't read it the way you do. I am going to dismiss the case.
Thank you.
Thank you, Your Honor. Next case on the agenda, Jean P. Palma, case 2024-00272, Code Officer Cody McGuire, page 23 of your agenda. Expert on the case is Deborah Burns.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am.
What page on the agenda?
23.
Thank you. Please proceed.
Okay. Cody McGuire, Citrus County Code Compliance Officer. Case number 202400272, conflict with Central Water Facilities, section 42-39B. Address is 886 South Line Road, Lecanto, Florida. Property owner is Jean Palma. Good service, signed certified mail return receipt, and posting at the Canto Government Building. I'd like to authenticate the following documents and be requested they be admitted into evidence. Exhibit A, copies of the notices from utilities for water connections 365, 270, 180, 90, and 30-day notices. And Exhibit B is a copy of notice of violation, copy of notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Is there anyone from the public who wants to be heard on this case? All right, let the record reflect there is no response. I do want to apologize to everyone. We are running, I think, by my standards, a little behind. Those couple hearings did take a long time. We are going to take a break at some point because I can't do it without lunch, but I'll keep you updated on what we're thinking. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence. Go ahead.
Okay. On March 6, 2024, I received this case for failure to connect to public water systems and found that there were no permits to connect. As of my final inspection on May 14th, 2024, there has been no permit applied for. And I'll now turn this over to Deborah Burns for utilities.
Okay, I have been in contact with Mrs. Palmer. She called after, I guess, receiving the notice of
Debbie,
hearing.
Can you move the microphone?
Sorry. They are in the process of obtaining a medical waiver.
Well, I mean, but they haven't submitted any. When did you hear from her on this?
It was after March 6th. I believe it was, no, not March. It was after the notice of hearing.
No, this is the notice of
The
hearing.
notice
On
of
March?
hearing was April 22nd,
She had contacted and left you a voicemail.
and I guess it was signed on
Okay.
the 29th of April. So you think it was
It
after
was
that?
maybe a couple weeks ago,
Okay.
yeah, that I have been in contact with her.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $50 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it's a respondent's responsibility to contact the Code Compliance Division when the violation has been abated or in order to allow for reinspection.
I will find that a violation has occurred, but I'll grant 60 days from today to abate it, which can either be by connecting or getting the waiver, in y'all's discretion. If it's not brought into compliance as ordered, a fine of $50 per day. Thank you.
Thank you.
Next case on the agenda, Star Havens, case number 2023-00900. Officer Timothy Williams, page 13 of your agenda. Experts on the case are Certified Building Official Samuel Acosta and Land Development Director Joanna Catu.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, ma'am. Please state your name.
Star Havens.
Thank you.
Good morning, or good afternoon.
Yes.
Yeah.
Morning.
Hey,
Timothy Williams, Citrus County License Compliance Officer. This is case number CE 2023-00900, Chapter 18, Article 1, Section 18-8A, obtain after-the-fact permits for all construction or modification of Citrus County Code of Ordinances. The address is 1500 West Sun Turf Street, Lecanto, Florida. Property owner, Haven Star. Signed good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted in evidence. Exhibit A, photos taken at my initial inspection on December 1st, 2023. Photos at my corrective action inspection on January 5th, 2024. And photos taken at my final inspection on May 14th, 2024. Exhibit B, a copy of the notice of violation, a copy of notice of hearing, a copy of the pre-hearing order, and a copy of the certified mail return receipt indicating good service.
Okay. Now, ma'am, I have 2 points I want to either ask or make to you. Number one is, are you contesting that a violation has occurred?
No.
Okay. If you're not, I indicated in my speech, I'm trying to help accelerate some of this stuff.
That's
but
okay.
If you are stipulating to that, how much time do you need, and have you talked to them about what you need to do to bring it into compliance?
I have talked to Sam's Mobile Home, and I've paid the money, signed the paperwork, and he's supposed to be submitting it, but it hasn't happened as of today. So I don't know. I live in Virginia, so this is all new to me.
So, Mr. Williams, is this a mobile home issue?
Yes, a mobile home on land.
And it just
without a
needs
permit.
to get a permit?
Yes,
Do you
sir.
need plans in order for that?
Site plan.
Site plan?
Yes, sir.
Well, so not engineered plans, sir?
They get a foundation, but mobile home setup guys are very well versed in what they need. So
Okay, so based on what you've heard, how long do you think that process could take?
I'll say at most 60 days.
Okay,
Yeah.
so you think that 90 days would be enough?
Oh, absolutely.
Sir.
Yeah.
Does that make sense to you?
Yes, sir.
What's your recommended fine?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost, to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised the violation.
Okay, thank you. So I think what I'll do is I will find that there's a violation, but I'll grant you 90 days from today to abate the violation. And if it's not brought into compliance as ordered, $50 a day. Okay?
That's fine.
All right. Is there anyone from the public who wishes to be heard on this case? I don't see anyone. All right, thank you.
Thank you, sir.
Next case on the agenda, Aviso Services LLC, case number 220-6345. Officer Keith Garner, page 6 of the agenda, expert on the case, certified building official Samuel Acosta.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Please state your name.
Chris Avizo.
Thank you.
Chris?
Yes, sir.
Okay. And Mr. Aviso, are you an owner and principal of Aviso Services?
Yes, sir.
Okay. Are you contesting whether or not a violation has occurred on the property?
No, sir.
Are you sure? No, I don't know anything. I just want to make sure. I don't want you to feel that I'm railroading the hearing. I just want to know. Look, if you're not actually contesting that a violation has occurred, then all I really need to know is how much time you need.
Well, I want to see what the violation was
Okay.
for.
All right. Please proceed.
Randall Garner, Citrus County License Compliance Officer, case number 220-6345. Chapter 18, Article 1, Section 18A, obtain after-the-fact permits for all construction modifications of Citrus County Code of Ordinances. Good service. I'd like to authenticate the following documents and request they admitted into evidence. 6/2024. Photos of my final inspection on May 14th, 2024. Exhibit B, a copy of notice of violation, a copy of notice of hearing, a copy of the pre-hearing order, and my posting affidavit and photos of the NOH posted at the property. But we did have a signed copy of the certified mail receipt afterward.
All right. So, sir, I'd like to ask you to take a look through these documents and let me know if you have any objection to them being evidence in this hearing.
These are just what was sent out and posted at the property.
Okay. Yes, sir.
Is it raining out there?
It was raining. It's threatening.
Really?
Smells like somebody's fixing lunch around here too.
Yeah. They're trying to break you. Don't let them break you.
We're number 9, I think.
Well, we do get to everybody.
I asked him.
All right, thank you. Did you have any legal objection to these?
No, sir.
Okay, then without objection, what's been proposed as Exhibits A and B are evidence. Please proceed.
On December 8th, an inspection was conducted at 11725 West Bayshore Drive, Crystal River. Photos taken regarding a complaint of construction without a permit. During my inspection, I observed a new slab in the back of the property, a dumpster with AC equipment, ducting scraps, and electrical wires. No contact was made with the owners at that time. The building permit was applied for on January 11th, 2024. There's been no activity to get this permit issued. During my follow-up inspection, I noticed the stop work postings have been removed, and I could not see if any further work had continued inside the house, and no permit has been issued as of today, or has been applied as of today.
What do you think?
I did hire a GC, and he ran away from trying to call him, text him. He hasn't responded. I did try.
Are they the ones who submitted for the permit?
Yes, sir. I did try coming here to see if I could file the permits myself. They said I have to do it online since it was already filed online. Go through the portal without the GC.
Okay. So I guess the issue here is how much time do you think you need? Your objective in order to bring this into compliance is to obtain that permit. How much time do you think you'll need? Legal counsel or have the county guide you?
Okay.
My understanding is that, okay, does that make sense?
Because it was bought as a off-market sale, so I had to use hard money to.
Again, please, I'm not providing legal advice. That's my understanding. You need to consult your own lawyer, et cetera, et cetera, et cetera. What's the county's recommendation?
Citrus County License Compliance Division this appropriate, given the severity of violation and respondents' actions relative to the violation. We'd also ask
I recognize that this case started several months ago, but you did retain a GC who applied for the permit, so.
Next case on the agenda, Douglas and Barbara Bertels, case number 2024-00175. Officer.
To tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Please state your name.
Douglas Bertels.
Thank you, sir.
How much time do you need to fix it?
Well, I have the hearing on the variance on the 18th of July. I'm seeking a variance too close to the wetlands.
Mm-hmm.
So I've been waiting for this hearing and trying to get a variance. I don't know what the time frame's going to be.
Are you, if the variance isn't granted, you'll have to either properly do whatever you have to with the pool or remove it.
Probably remove it.
Do you have to get a permit to remove a pool? An in-ground, or is it an in-ground, above ground?
Above ground.
Oh, okay, well, you just, okay. How much time? So you need at least 2 months, correct?
Yeah, I would say 60 days.
Through July.
Okay, then I would be prepared to do 90 days, and what's the county's recommendation?
$50 a day along with the administration cost after the date you deem sufficient to abate this violation.
All right, so I would grant 90 days to abate the violation, if not brought into compliance as ordered, to fine of $50 a day, okay?
Okay, that's fine.
Is there any objection from the county?
That's starting today, because there's hearings in July.
It runs from my order, but I'm worried that if the variance isn't granted, he'll still need a little bit of time.
Okay.
Yeah, all right, thank you.
Okay, thank you.
Next case on the agenda, Robert W. and Tony L. Ballard, case number 2024-00152. Code Officer Brandon Norman, page 7 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Wow, people still think they have the right to go to the bathroom? I mean, that's,
How dare they? No.
We give and we give and we give.
oh, was that for the Ballard case?
Yes.
Oh, okay.
Sorry, I didn't realize it wasn't in here.
Do you want to call another case?
I
while-
think he's coming.
Oh,
Oh, no, that's not him.
yeah, let's call another case.
Yep.
Let's get people out of here.
Next case on the agenda, Stephen and Maureen Mason, case number 202400543. Officer Keith Garner, page 20 of your agenda. Expert on the case, certified building official Samuel Acosta.
Is this Keith's case?
Yes.
He stepped out.
Sorry.
No? No?
Oh, he's
Oh,
right
he's
here.
back.
He's right
Okay,
here.
sorry.
All right.
I just saw him in the hallway. I was like,
As you know, my first question right now is whether or not you're contesting that a violation in, okay.
It wasn't a violation. It was a mistake.
What was a mistake?
The whole thing.
Saying that this is, well, actually, let me ask the county. I don't want to.
There you go.
Is it your understanding that the case has abated?
No, they've actually applied for the permit for the shed, and we're
No,
waiting
that's
for
a
that.
different permit than.
Violation, it sounds like there's a dispute, so I'll let you proceed.
Okay, go ahead with this.
Yeah, please.
Okay. I'm sorry, let me get the right one up, that's what I was waiting to do. Mason. Randall Garner, Citrus County License Compliance Officer, case number 202400543, Chapter 18, Article 1. Mason, good service via posting at the property in the Lecanto Government Building. I would like to authenticate the following documents and request that they are admitted into evidence. Exhibit A, photos taken during my initial inspection, March 21st, 2024. Photos taken at corrective action inspection on April 22nd, 2024, and photos at my final inspection, May 14th, 2024. Exhibit B.
This is about?
Okay, so there was a permit that was expired in 2021, and I was chasing down this permit. Come to find out, there was an earlier permit that was finaled for the same thing. So that abated that part of the violation.
So,
And right now.
but wait, you're telling me that there was a 2021 permit that expired?
Right.
But there was one before that that was finaled?
That was finaled.
Why would the subsequent permit have been pulled?
I was questioning that myself.
Okay, that'll make you question some things.
Sure, and it was, anyway, so the shed was the only other thing that was in violation.
Well, what was that first thing about?
An addition to the home.
An addition,
Actual
so that's
addition.
not at issue. What's at issue here is a shed.
The shed.
Okay.
And there's actually a permit that was applied for on 3 May and is currently not issued. As far as where it is right now, I did check to see if the permit was issued yet.
I just want to make sure I understand then before I turn an
It
application.
goes back to the applicant for them to
Okay.
fix what was denied.
As far as you know, has whatever.
Not at this time.
Okay. Does it make sense what they're saying?
We're not familiar with
To fix something that they want to see in your permit application, okay?
what it is.
It says here that
And there, apparently you have filed a permit, an application for a permit on May 3rd. That's what you need to.
Brought that stuff in, that was completed.
So here's the deal. I mean, unless you're going, ma'am,
To find out what we need to finish.
that's right.
Okay, because we've already brought the drawings in, which
Is you've got to go see and fix whatever it needs and take whatever they said it was denied for, get it fixed. All right, what's the county's recommendation?
Citrus County Code of Compliance respectfully requests special master assess a fine of $100 to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owners once they were advised of the violation.
I only do that for the record, so then I don't have to go through a bunch of other
I'm just
things.
saying, if we need a permit for it,
Anyone from the public who wants to be heard on this?
it's a shit.
Exhibits A and B are evidence. Mr. Garner, can you tell me a little bit about the shed?
Like I said, they had just put in the permit on 3 May to get this abated.
To the shed being required to be permitted?
Yeah.
All right. What's the recommended fine?
$100 a day.
Next case on the agenda, Robert W. and Tony L. Ballard. Case
Bless
number.
Sir? Oh, did I? Do you swear or affirm?
Testing whether a violation has occurred?
No.
Okay. Then, all right, so what's the recommended fine?
We recommend $200 per day.
Do is I will grant you 30 days from the date of the order to bring the property into compliance. And actually, I'm sorry, is there anyone from the public who wants to be heard on that case? All right.
Which address was that?
That was. Okay.
Officer Timothy Williams, page 18.
What is your name?
William Berry.
William Berry. Is this page 18 of the agenda?
Yes, sir.
Okay. I welcome. Go ahead, Mr. Williams.
This is case number CE 2024-0. Noria de Fritos Suarez. Good service via signed certified mail return receipt. I'd like to authenticate the following documents and request they be admitted. Exhibit A, photos taken from the initial inspection on March 11th of 24. Corrective action inspection on April 17th of 24. And final inspection on May. Exhibit B, a copy of the notice of violation, a copy notice of hearing, a copy of the pre-hearing order, and a copy of the certified mail return receipt indicating good service.
Okay. You don't have a power of attorney, do you, from the owners?
No.
Okay. Is there anyone from the public who wants to be heard on this case? All right, then, I would just, and I'm not trying to be rude, it's just you don't have standing to represent them as a party. I will want to hear from you.
Okay.
But do you want evidence?
Yes, sir.
I don't know if they want to look at the documents or.
Oh, is this one? Okay.
Okay. Without objection, what's been proposed as.
Florida, and photos were taken regarding a building without a permit. During my inspection and research, I observed the construction of a new residential home being built without an issued permit. A notice of violation was issued on March 14th, 24.
Is there anyone else from the county who wishes to testify? No? Okay. I would like to hear from you.
So,
You have a permit number from the county?
yes, yep.
Okay. Do they have a permit number? So normally on these cases, y'all tell me that the violation is abated upon issuance of the permit.
Couple weeks, but they're so backed up. I mean, if we
Yeah.
had 60 days.
If not brought into compliance.
Okay.
Good luck.
Thank you.
That's it. You're done. Yeah.
Next case on the agenda, Michael Holland, case number 202400.
He has permits in the building that have not yet. Go ahead.
So you were saying?
He has permits that were applied for on 5/9.
Do you have any idea of the sufficiency of the application or?
Well, it's in a flood zone, so it's gonna have to pass the review for that.
So, Mr. Holland, do you have, it's hard, I don't think you would necessarily know how much time this will take.
Right,
Yeah.
well, the carport's already tied down.
Yeah.
Maybe 60 days to get the outbuilding tied down. I think setbacks, everything's, I'm talking with the county, everything's good there. I just need to anchor that building.
Does that sound about right to you?
That does.
All right. So you'll stipulate that there have been and are some remaining violations, but that you're taking care of them.
Right.
Okay. What is, I mean, is 60 days enough to fix everything?
Yeah, I think so.
What's the county's recommendation on fine?
$100 a day.
Okay, 60 days, $100 a day.
Okay.
That's it. Good luck.
All right.
Next case on the agenda, Naughty Time LLC, case number 2187640. Officer Keith Garner, page 22 of your agenda. Expert on the case, certified building official Samuel Costa.
You guys are taking over these hearings.
Had nothing better to do today. Case number 2187640, Chapter 18, Article 1, Section 18.8A, obtain after-the-fact permits for all construction modifications, Citrus County Code of Ordinances. Address 10317 West Yulee Drive, Homosassa. Property owners Naughty Time LLC. Good service via certified mail return receipt. I'd like to enter the following documents, request they be admitted into evidence. Photos taken during initial inspection, December 5th, 2023. Photos taken as re-inspection of February 28th, 2024. And my corrective inspection, April 15th, 2024. Photo taken at my final inspection, May 14th, 2024. Copy of notice of violation, copy of notice of the hearing, copy of the pre-hearing order, and a copy of the certified mail receipt indicating good service. On December 5th, an inspection was conducted at 10317 West Yulee Drive, 34448, and photos were taken regarding complaint of unpermitted items on the property. During my inspection, I observed an ice machine dispenser that was installed without a permit with electric and plumbing. No building permits had been applied or issued. I received a call yesterday stating the ice machine was going to be removed today, but my inspection yesterday showed that it still remains. Expert witness in this case is Land Development Director Joanna Coutu and Building Official Samuel Costa.
Okay. Is there anyone from the public who wants to be heard on this case? No? Mr. Acosta?
I would require a permit for the plumbing connection and ensure that it's part of my side and the electrical work.
I mean, whether it's removed or the work is permitted, this doesn't sound like, thank you, like it'll take a huge amount of time. Ms. Coutu, you were listed as an expert as well. Oh.
Only to the extent that they have converted it into a sit-down restaurant, and we don't have any permits for that. So we know about a takeout restaurant there, and we know of 3 parking spaces for that, which is why they didn't have sit-down. Now they have sit-down, which is a concern. They do need to come through permitting for that.
Yeah, okay. Well, I'm worried about what the amount of time I should give is, or that's reasonable. I'm inclined to give 30 days, to be honest. I'm fine.
$100 a day.
Okay, I'll grant 30 days and $100 a day.
Next case on the agenda, West Nature Coast Investments, Inc., case number 202400536. Code Officer Amy Becker, page 29 of your agenda.
Thank you. Thank you, Jim. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Good afternoon, sir. What is your name?
Jim Morton.
Are you an owner or officer of West Nature Coast Investments, Inc.?
I am an owner.
Okay. And are you contesting whether or not a violation has occurred on the property?
No.
Okay. How much time do you need to fix it?
It's fixed.
It's
We don't
fixed?
need any time.
Is it fixed?
I don't know. He said he was gonna be done yesterday at 5 o'clock, and I did not make it back, so I told him I'd inspect this afternoon.
Okay.
If I could have 2 weeks, because our contractor guaranteed it would be done, but because of the tornado warnings, he didn't get it
Yeah.
done. our fault. We
It's
should
gotten
have.
dicey out there. What's the county's fine recommendation?
$50 a day.
Okay. I'll grant 15 days and $50 a day.
Thank you, sir.
Thanks.
Thank you.
Next, two cases on the agenda, Lewis and Carrie Schiani, case numbers 2024-00233 and 2024-00357. Code Officer Brandon Norman, pages 24 and 25 of your agenda.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
We do.
Please state your names.
Louis Shiani.
Carrie Shiani.
Thank you.
Mr. and, are y'all siblings or married?
Husband and wife.
Husband and wife.
39 years.
Congrats. Mr. and Mrs. Shiani, are you contesting whether or not a violation in either of these cases has occurred?
No.
Okay. So in one case, we have, it looks like a vehicle case, and one is what I call a junk case. How much time do you need to fix both of these violations?
I've addressed the vehicle problems. I'm sure you can attest to that.
I'll talk to him about it,
Yeah.
but so how much time on the junk?
Give me 90 days, I'll have it all done.
Mr. Norman, is there still a violation regarding the vehicles?
As of yesterday, there was.
Okay, and what is it?
The yellow Volkswagen Bug doesn't have a visible registration sticker. It's unreadable.
So he's saying that you still have an issue with the yellow Bug.
Okay.
Are y'all aware of that?
I was aware of the white van. I don't understand about the yellow bug. It's got a tag on it. It's not registered, but it's well kept.
Well, that's the issue.
Well, if I moved it up from there or covered it, would that be fine?
If it's in an enclosed structure like a garage or
How about
detached garage, a car cover won't evade the violation. No.
Okay. I can move that to my garage.
And it has to not be.
No, it won't be seen. I got a 20 by 20 garage there.
Okay, so you really don't need much time for that.
Well,
and you're-
any time, I guess from my other side of the yard, is that where
Yeah,
one
that's
of
the
your
next one.
problems?
So
I'm sorry.
Excuse me, yeah. So,
Rush it.
you're saying 90 days on the junk case.
Yes.
Mr. Norman, I don't want to do 90 days unless I see the photos, because the photos.
I'll give you exhibits A and B for both.
Okay, yeah.
Could we see them as well?
Yeah, look at them first.
No, not yet, wait.
Well, I assume y'all have a generator.
Yeah, it'll keep.
Yeah. Yeah, I have one too.
We do about the other side of the yard.
Yeah, we got a lot of this
Not-
taken care
You're
of
not
already.
too happy.
That's
Now,
my son.
did you take photos yesterday as well? Is that it? Okay.
Yeah, over here.
No, it was April 8th, I was gonna say, because we cleaned that up again. Okay, now that's gone. It's cleaned up a little bit, that's old. 8, 14.
And I like, you know, I can't, I understand this here. Yeah, I would like to.
Okay.
And these are the corrections? This is for the. Yeah, this is gone. This is all taken care of. It's just photos from the inspection.
Yeah.
Okay, where's the ones that you show? This is just,
Guys, so I just wanted to look at the photos to determine what the appropriate amount of time was.
Yeah, the 90 days would be good for the debris in the other yard.
I just want to make
Car
sure
is-
I want to make sure it's not setting y'all up for failure, so.
oh, thank you.
Yeah,
So you understand, I work 6 days a week.
Yeah.
I get up at 3 in the morning, and I don't get home until 6, 7 at night, so also keep that in perspective.
I get it, I get
build
it.
roads and bridges.
I get it. Mr. Norman, do you have any immediate health sanitary, this doesn't, do you have any sanitary concerns?
No, not as of today, no.
Okay. All right, then I'm going to admit both exhibits A and B, which you've looked at in each case. What I'm going to do is I'm going to grant 10 days to come into compliance on case number 24-357. And what's the recommended fine if he can't fix the bug?
50 for both violations.
Okay, so it'd be $50 a day if you can't find a way to fix the bug issue in 10 days. And in case number 24-233, I'll grant 90 days, and the fine will be $50 if you don't bring it into compliance, okay?
Thank you very much.
Is there anyone from the public who wants to be heard on these cases? No response. Thank you.
Thank
And good luck.
Thank you.
Next, two cases on the agenda, Alan J. Campbell, Donna Sweet, and Raymond Eli Blauser. Case numbers 2024-00432 and 2024-00444. Code Officer Brandon Norman, pages 9 and 10 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Okay, good afternoon, Brandon Norman, Citrus County Code Compliance Officer. This is for case 2024-00432, temporary occupancy of a recreational vehicle, a violation of Citrus County Land Development Code Section 3140 under the Temporary Uses Table 3-2. In case 2024-00444, special requirements for all accessory structures, a violation of Citrus County Land Development Code Section 3102, subsection A. This is for address 4125 South Aliana Terrace, Inverness, Florida 34452. Property owners listed as Donna Sweet, Raymond E. Blauser, and Alan J. Campbell. And I have good service via posting of the property in the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence for both cases. Exhibit A will be photos taken during the initial inspection on March 5th, 2024, the corrective action inspection on April 22nd, 2024, and the final inspection done yesterday, March 14th, 2024. Oh, I'm sorry, May. I misspoke. May 14th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the posting affidavit that I completed with a photo of the posted notice of hearing for both cases of the property.
Is there anyone from the public who wants to be heard on this case? Okay. Thank you. Without objection, what's been proposed as Exhibits A and B in each case are admitted as evidence.
On March 5th, 2024, I conducted an initial inspection of the property for a complaint of an RV occupancy of greater than the 14-day period. I observed the property to be in violation due to meeting with the occupant of the RV and confirming with him that he did in fact reside inside the RV. He stated that he wanted to convert the RV to a principal structure. I informed him on how he would need to go about that to find out if that was a possibility. Due to no principal structure being present on the property was also found to be a violation of the storage on a vacant parcel ordinance. The property remained in violation of...
Was the person in the RV one of the owners?
He never gave me his name.
Okay.
The property remained in violation of my corrective action inspection on April 22nd, 2024, and as of May 14th, 2024, the property remains in violation.
Did you ask for his name?
I did.
Okay.
He just declined to give it to me.
Ms. Coutu, do you have any testimony? I mean, you never know.
He beat it in the ground or whatever, but it is vacant because code removed a mobile home unsafe structure in 2022. So this is a vacant lot. It could have a mobile home. It's a little under a quarter of an acre.
Was I involved in that case?
I don't know. 2022, were you here?
Yeah.
No, I don't believe there was.
Oh, okay, gotcha.
There you go.
All right. I would love to hear from the public. Sir, would you like to be heard? You've been patient.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name?
Roger D. Alvar Jr.
Thank you.
I live kitty corner from that address. He had a shed. They repoed it. Then he brought the camper. And then all the other stuff. He has no electricity, no water. The generator runs 24 hours a day, which is like...
You can hear it.
It's the resonance, and it's the smell. It's the... Yeah. Please.
And you said he, so who is he?
He, the one that he declined to give his name.
Okay. You don't know his name either? Okay. All right.
Beyond that, most disruptive, he does not care. I don't know if you want to hear all the drug stuff in that neighborhood, but 10 o'clock at night, let's start the Harley, and it doesn't run. I think they repoed that too, so, that's all, really.
All right, well, thank you, sir.
For that matter. Thank you.
Thank you. Mr. Norman, so on one of the photos from April 22nd, I see two people, a guy in a black shirt. Is that the guy who you spoke with?
That's affirmative.
And who's the woman in the blue?
I'm unsure. She wouldn't identify herself.
So no one was identifying themselves, okay.
I try to be as polite as possible, but some
Sure.
people just don't want to talk that much with me. I don't know why.
Let's see. What is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs for each case to begin after the date that you deem sufficient to abate these violations. It was selected based on the actions of the property owners once they revise the violation and it's appropriate given the severity of the violations and the respondent's actions relative to the violations. We'd also ask the special master to find it's the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
I think based on public input, I'm gonna have to bump it up. But I will find that a violation has occurred in each case. In case number 24-432, I'll grant 14 days to bring it into compliance. If it's not brought into compliance, $300 a day. In case number 24-444, 14 days and also $300 a day.
Great,
Thank you.
sir.
Next case on the agenda, Anita Lafree, case number 2024-00521, Code Officer Brandon Norman, page 19 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
This is actually one street over, so
Okay.
very popular area.
So are you going to want to be heard on this case too?
It's my neighborhood.
Yeah, it is. Okay.
This is, I'm sorry, Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2024-00521, special requirements for all accessory structures, a violation of Citrus County Land Development Code, section 3102A. This is for address 4229 South Plum Tree Terrace, Inverness, Florida 34452. Property owner listed as Anita Lafree. I have good service via posting of the property in the Lecanto Government Building, and I'd like to authenticate the following documents and request they be admitted to evidence. Exhibit A will be photos taken during the initial inspection on March 19th, 2024, my corrective action inspection on April 22nd, 2024, and my final inspection done yesterday, May 14th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the posting affidavit that I completed with a photo of the posted notice of hearing of the property.
Without objection, what's been proposed as exhibits A and B are evidence.
On March 19th, an initial inspection was conducted of the property for storage on a vacant parcel. The property was found to be in violation with an RV and a shed on the parcel with no primary structure present. I observed individuals shuffling around behind the RV, but no one would make contact with me. The property remained in violation of my notice of violation corrective action inspection on April 22nd, 2024, as well as my pre-hearing inspection done yesterday, May 14th, 2024. I haven't had any contact with the property owner, but I have dealt with her other properties in the past in the area.
Have you ever dealt with the property owner before?
I have before.
Okay, so you know she's around.
And we brought one of her properties into compliance, most
Okay.
recently, actually.
Interesting, all right. Anyone else from the county?
Is a vacant property about 0.2 acres, RUR, mobile home, should be vacant.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $200 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. It was selected based on the actions of the property owners once they revised the violation, and it's appropriate given the severity of the violation. We would like to ask the special master to find its respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
Sir, I'd like to hear from you if you have anything to say.
No.
Okay. In that case, 14 days, $300 a day.
Thank you.
Yep.
Next two cases on the agenda, Camelia Hernandez, case numbers 2024-00454 and 2024-00463. Code Officer Amy Becker, pages 14 and 15 of your agenda.
Good afternoon.
Yep, good afternoon.
Amy Becker, Code Compliance Officer. Case number 24-454, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A, and case number 24-463, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address for both is 2291 West Landmark Drive, Citrus Springs, Florida. The property owner is Camelia Hernandez. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, for both cases, photos taken during my initial inspection on March 8th, 2024, photos taken on March 27th, 2024, and my corrective action inspection, photos taken on April 30th, 2024, showing the posting of the property, and final inspection on May 14th, 2024. Exhibit B, a copy of the notice of violations, a copy of the notice of hearings and pre-hearing order, and a copy of the posting affidavits.
Is there anyone from the public who wants to be heard? Nope. All right, without objection, what's been proposed as Exhibits A and B are admitted as evidence. Thank you.
On March 8th, 2024, I conducted my initial inspection for accumulation of junk and debris and observed discarded furniture in the backyard and some trash, and observed the lawn in excess of 18 inches. As my final inspection on May 14th, the property remains the same, still overgrown lawn and still debris in the backyard. I have not had contact with the owner. I've been told the owner's deceased. I did not find a death certificate. I did find an obit.
Well, let's see. Okay, what's the county's recommendation?
On case 24-454, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50. And on case 24-463, $50 as well, along with administrative costs to begin after the date you deem sufficient to abate these violations. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. And we would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
30 days in each case and $50 a day.
Thank you.
Yep.
Next case on the agenda, Dorothy Stukin, case numbers 2024-00501 and 2024-00502. Code Officer Alan Jonason, page 26 and 27 of your agenda.
Well, your big chance.
I'm looking forward to this. I've been waiting all day. Lori.
It's okay. You have to swear him in. Oh, I forgot I haven't seen him. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-00501, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Also, case number 2024-00502, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 175 North Chickadee Point, Inverness, Florida. Property owner is Stukin Dorothy. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 13 March 2024, photos from a compliance inspection on 18 April 2024, and photos from my final inspection conducted on 14 May 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
Okay. There's no one left from the public. And so it's been proposed as Exhibits A and B in each case, I presume? Is this just one set for?
I just did label them A and B, but everything is in there for both of them.
Okay.
Yes,
Then
sir.
I'll admit these same exhibits for both cases.
Okay.
Both cases.
On 13 March 2024, I conducted my initial inspection and observed the property to be in violation. On 18 March 2024, a notice of violation was issued for junkyard conditions and excessive growth and accumulation of vegetation, which is a violation of the ordinances mentioned earlier. On 18 April 2024, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 14 May 2024, the property remains in violation.
It's interesting, there was a signature, but it doesn't appear to be that name.
The property appears abandoned, I'm not
It
for sure.
does, yeah. All right, what's the county's recommendation?
$100 per day per violation.
All right, 30 days in each case and $100 a day if not brought into compliance.
Thank you.
Thank you.
Next cases on the agenda, Raymond K. Gewich Jr. and Virginia L. Orphan. Case numbers 2024-00356 and 2024-00445. Code Officer Brandon Norman, pages 11 and 12 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2024-00356, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Case number 2024-00445, abandoned, unserviceable, unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. Address is 6700 South Dove Drive in Floral City, Florida, 34436. Property owner listed as Raymond K. Gewich Jr. and Virginia L. Orphan. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request to be admitted to evidence for both cases. Exhibit A will be photos taken during the initial inspection on March 5th, 2024, corrective action inspection on April 22nd, 2024, and final inspection on May 14th, 2024. Exhibit B will be a copy of the notice of violation, copy of the notice of hearing, copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
All right, there's no one from the public, and what's been proposed as Exhibits A and B is admitted as evidence in each case.
On March 5th, 2024, I conducted an initial inspection of the property for a complaint of junk and debris and inoperable vehicles. I observed the property be in violation due to improperly stored junk and debris, household trash, as well as tree debris and other miscellaneous debris, as well as inoperable vehicles and trailers in the yard. I've had contact with the person who lives at the property, and we discussed what they need to do in order to bring it into compliance. The property remained in violation at my corrective action inspection done April 22nd, 2024, and as of May 14th, 2024, the property remains in violation. He has been working towards it. He is disabled. He was going to try to be here today, but he couldn't.
Do you know what the nature of the disability is?
I don't know. From what he's explained to me, it's his back.
Okay.
So, and from observing him walk around the property, it would coincide with that. I believe he's the son of the property owner, is how he's explained himself to me. He did have an after-the-fact code violation case due to the barn that was in the initial photos. They've since brought that into compliance, but because of that, everything that was in that barn has now spilled out.
What's your recommendation?
Recommend $50 a day for each case.
All right, I'll grant 60 days in each case and $50 a day.
Thank you.
Thanks.
Last case on the agenda, Arrowhead Investments of Southwest Florida LLC, case number 2024-00200, Code Officer Brandon Norman, page 5 of the agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is for case C 2024-00200, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for 7109 East Gun Court, Inverness, Florida, 34450. Property owner listed as Arrowhead Investments of Southwest Florida, LLC. And I have good service via posting at the property in the Lecanto Government Building. I'd like to authenticate the following documents requested to be admitted to evidence. Exhibit A will be photos taken during the initial inspection on February 22nd, 2024, my corrective action inspection, April 8th, 2024, and my final inspection, May 14th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the posting affidavit that I completed with the photo of the posted notice of hearing of the property.
There is no one left from the public. What's been proposed as Exhibits A and B is now evidence.
On February 22nd, 2024, I conducted an inspection of the property for a complaint of junk and debris and unlicensed inoperable vehicles. I found the property to be in violation of both ordinances due to improperly stored junk and an unregistered vehicle in the yard. The property remained in violation of my corrective action inspection on April 8th, 2024. I did have contact with the property owner, or one of the property managers, and they said they were evicting the tenants at the property. They since abated the unlicensed inoperable vehicle case, but as of yesterday, you can tell that they are cleaning up the property, but the junk and debris violation remains.
What's your recommendation?
$50 a day.
60 days, $50 a day.
Thank you.
And that was the last case. Is there anything else that the county wants to take up? No. The time is 1:15. This hearing is adjourned.